For orders, item number 5.
Mr. S.K. Mehdi is on his legs and it may be passed over for the time being as per his request.
Okay, passed over for the time being.
For admission, item number 1.
Lordship, the order passed by this court was affirmed by the division bench, and the respondent has filed an appeal before the Honorable Supreme Court, and the SLP was dismissed, my lord.
Okay, let us see the order passed by this court,
My lord.
first of all. Just leave it.
That is at page 120, my lord.
This is WPC 71.
Yes, my lord.
What was the direction?
The direction was to pay the amount along with interest under section 34 and 28. Your Lordship will come to page 126, para 13, 13. With your Lordship permission, I'll read this, my lord.
Okay, not necessary.
My
It's
lord.
okay. Then after this, what happened?
After this, the respondents have filed an appeal against this order.
What is the appeal? Where is the appeal?
I have supplied a copy of the appeal, my lord.
This one?
Yes, my lord. The appeal is registered as WAF 5 of 2023. The order date is 28/10/2024. So the division bench of this court does not find any ground to interfere with the impugned judgment and order.
WA number 5 of 2023. Okay, thereafter, what was filed?
Thereafter, SLP was filed before the Honorable Supreme Court.
SLP.
SLP number is 5720 of 2025.
This was against,
It is against order dated 28/10/2024, arising out of WA number 5 of 2023.
what is the date of the order?
7/3/2025.
So there's no confusion about it.
No confusion, my lord.
Writ petition, writ appeal, then SLP.
Yes, my lord.
So now what remains is the compliance of the judgment passed by the single judge,
Yes, my lord.
which says that
Now it has directed the collector, district collector.
3
my lord.
to 6.
Yes, my lord.
Collector shall forward the same to respondent 3 to 6 after making calculation.
Yes, my lord.
And who are 3 to 6? Then 3 months. So collector has been directed to make
A calculation.
calculation under 34
Yes, my lord.
and
Under
also
28.
under 28 also.
Yes, my lord.
Where is that 28 part? Yes. Section 34 and 28.
Now, in compliance of this court order, my lord, the district collector has made a calculation.
Okay.
That is at page 177, my lord.
Yes.
Now the amount has come up to 19 crores 18 lakhs 43,087.
Yes.
I think the amount would have increased by now, my lord. And now the only thing that remains, as I understand, is that the respondent herein has no other option but to pay the amount as directed by this honorable court.
Yes. Who is appearing? Mr. Subedi?
Yes, Your Lordship, as I was, this case is disposed of recently, so in furtherance to this, I need to take instruction from the company as to what next step.
You're for the NPCC, isn't it?
Yes, yes,
So against the judgment of the single judge, you went in appeal.
yes,
Appeal is dismissed.
dismissed,
Again, you went in SLP,
Dismissed.
that was also dismissed.
dismissed, yes,
Now, what is left is to comply with this single judge's order.
yes. I'm only,
Who are the
praying-
respondents here? Why were you saying the other day there's a confusion about this case?
Because before admitting this SLP,
Huh.
the Supreme Court registry has only given the dairy number. Only the dairy number. Now, here we have a different SLP number. So the registry is confused with the dairy number and the SLP number is not the same. So they refuse to list this matter.
Diary number is initially it will be diary number.
Yes, my lord.
Then it will be SLP.
Before admission
After
of
admission
SLP.
of-
No, diary number, then on SLP.
Yes, my lord.
Then after SLP number is there, if it's admitted, then it is made as what?
Civil appeal.
Civil appeal.
Yes.
So again, number will change.
Yes.
So there are three numbers.
Yeah,
Diary
that-
number, SLP number, and civil appeal numbers.
that is how I understand, my lord.
correct.
So who are the respondents here? Are they relevant as on today?
As of now, there is no change of, I think, incumbents, according to us. But I think my other friend is. may-
Even that also.
You are appearing for which respondent?
4, 5, and 6. Basically, 6. 5 is the CMD, and 6 is the zonal manager,
No, 5 is the CMD.
CMD.
They are still holding their position?
As far as I know, this CMD is still there, as far as I know. I need to clarify, but as far as I know, till now, is there. And 6 also.
So how much time should you require?
My lord, at this stage, 4 weeks' time may be granted.
Not to clarify, for compliance.
The steps will be taken accordingly within that time.
So we'll grant you 4 weeks' time to comply with the direction. Failing which, they'll be answerable. Okay? You have been actively participating. First of all, judgment by single judge, then you file appeal. Again, you went to Delhi and filed SLP.
I am hopeful. I am very.
So they know what is what.
Yes, yes, yes,
It is not that they don't know.
yes,
It is your SLP.
yes, yes.
It is your writ appeal.
Correct.
So you know what has happened. So you should now take steps to comply with it.
Yes.
Because that is the last resort,
Yes.
SLP.
And
After there's
in
no
4
other
weeks'
provision.
time, I am very hopeful that something will come out between the ministry. They have
Okay,
to
please
communicate
write
with the
down.
ministry and all that.
Heart, Mr. Seelal Faxwal, learned counsel for the petitioners, who submits that this contempt petition has been filed for willful and deliberate violation of the court's direction passed by judgment and order dated 4/12/2019 in WPC number 71 of 2018. Stop. Next para. the learned counsel submits that the respondent NPCC, being aggrieved with the same, filed writ appeal number 5 of 2023, which, however, was dismissed on 28/10/2024 with a direction to the respondent, with a direction to the appellants to comply with the direction of the learned single judge. Next para. Still being aggrieved, the NPCC filed SLP C number 5720 of 2025, which again was dismissed by order dated 7/3/2025. Stop. In support of his submission, the learned counsel has drawn the attention of this court to page 119 of the contempt petition and has also furnished a copy of the order dated 28/10/2024 passed by the division bench and the order dated 7/3/2025 passed by the Honorable Supreme Court. Stop. Next para. The learned counsel submits that the Deputy Commissioner cum District Collector, Longklai, in terms of the direction passed by the learned single judge, has made the calculation for the interest payable to the petitioners and forwarded the same to the authorities concerned on 28/1/2020, bracket annexure 3. Don't close the bracket. Annexure 3 at page 177. Close bracket. Stop. The learned counsel submits that as per the collector. No, cancel that. The learned counsel submits that the collector has made an assessment to the tune of rupees 19,18,43,087. This amount will go higher.
Most probably, ma'am.
How will that be?
Because the interest
Till
will be there
till final payment.
Yes, madam.
Okay.
And this 19 crores is inclusive of administrative cost,
Comma, inclusive of administrative cost.
2%.
Full stop. The learned counsel submits that since the calculation was made in January 2020, comma, the amount as on today should be more since payment has not been made till date. Next para. At this stage, Mr. Roshan Subedi, learned counsel, representing respondent numbers 5 and 6, submits that he may be given 4 weeks' time to obtain instructions in the matter. Full stop. Since it is the NPCC who had filed the writ appeal as well as the SLP as referred to herein above, comma, it goes without saying that they are aware about the outcome of the SLP as well. Stop. Since there will be no further option after a call has been taken by the Honorable Apex Court, comma, the respondent and PCC will have to comply with the direction passed by the learned single judge. Stop. In view of above, 4 weeks' time is granted to comply with the direction passed on 4/12/2019. List the matter again on today's 24th. 29th of April 2025. Respondents to submit their compliance report by then.
What's obliged?
like that.
The orders produced by Mr. Silal Faxwala, learned counsel for the petitioners, shall be retained on record.
Item number 2.
My pleasure, Lordship. My Lord, this case has been taken up by Miss Mary. So, my Lord, she's in another court, so it may be passed over for the time being, my Lord.
She's there with you.
Okay, my Lord.
2 is, my Lord, relating interest of 34, my Lord, 34. And, my Lord, this RTP is pending, my Lord, in other cases are fixed on 7th of April, my Lord. This, initially, it was 0 value, my Lord. Subsequently, reference code fixed the land value, my Lord.
How many cases of similar nature is pending?
My Lord is, including this 8, my Lord.
8.
7 or 8, my Lord. Yes, my Lord.
And how many writ appeals?
Writ appeal 2 writ appeals.
2 writ appeals.
Yes, my Lord. On 6 and 27th of this coming, my Lord.
Do you have the number, writ appeals?
Yes, my Lord. It is, my Lord, 265, 2023.
Sorry?
265,
265,
2023.
23,
And 320 of 2023.
320 of 2023. And they are due to come on
My Lord, 27th of this coming month, March, my Lord.
27 March,
Yes,
this
ma'am.
Thursday?
27, yes, ma'am.
Okay, so other matters we have listed on some date.
7, my Lord.
So this will go on 7th
Yes,
also?
ma'am. Yes, ma'am.
Mr. Lianshima? Please write down, parties are represented by the respective councils. Stop at the outset, Mr. S.K. Mehdi, learned CGC, for the petitioners submits that the outcome of writ appeal number 265 and 320 of 2023, pending before the principal seat of this court, would squarely cover the instant case. Stop, since the writ appeals are due to be listed on 27th of March 2025 for consideration, comma, the instant writ petition may be listed on 7th of April 2025. Stop. Next para, the said prayer is not opposed to by the learned counsels for the opposite parties, and accordingly, let this matter be listed on 7th of April 2025. Mr. S.K. Mehdi shall inform the court about the status of the writ appeals on that date.
Yes, my Lord.
Item number 3.
My pleasure, Lordship. My Lord, with regard to this case, I have received Parwai's comment on the past Friday. So I may be given time, my Lord, to file my affidavit, my Lord.
Otherwise, comments.
My Lord,
You are which respondent?
I'm for the state respondent, my Lord. I'm for the state respondent, my Lord. Respondent number 1, 2, 3, 1 to 4, my Lord.
1 to 4.
My Lord.
What is your instruction?
Basically, my Lord, instruction is that the state respondents are acting merely on the in the compliance of the court's order, my Lord. That's it.
Lower court's order.
My Lord.
They transfer the location.
Transfer, my Lord. Yes.
So what is there to file then? Mr. Lianshima, what is your case otherwise?
My Lord,
Somebody has seen your land,
my Lord,
and although he has a dispute before the court with another party, since there was some overlapping,
my
so
Lord.
suddenly he notices there's a vacant plot of land. Then he points finger at a plot of land, said, transfer my land there. In the meantime, what you had done was you had in fact applied for that land,
Right, my Lord.
and the process was on.
Right, my Lord.
Because of the order of the court saying that you transfer the land, it cannot be processed.
Right, my Lord.
So you are seeking cancellation of that order
Yes,
passed
my
by that learned trial court.
Yes, my Lord. Because the civil court does not have any jurisdiction to make allotment of land. And apart from that, the respondent number 5 has not sought for relief of the type, transfer of location from here to there in his plaint, my Lord.
What does it say, your instruction regarding the process made on the application made by Mr. Liantrima's client?
My Lord, as I have already mentioned, basically it states that the order of the court was compliant by the state respondent. That's it, my lord. So, my lord, in case this case is going to be proceeded, my lord, my prayer may be reflected, my lord, in that case.
Definitely. See, if there's some substance in your instruction, definitely I would have given you time to file affidavit. But
My
if
lord.
you just say that we are doing this step because of court's order, there's nothing to
basically
write.
that, my lord.
There's nothing to file.
It's basically that.
So let me hear Mr. Liantrima. We'll see what can be done.
May I please, Lordship? The present revision petition is directed against the order dated 8/12/2023, passed by the learned District Judge, Aizawl, in RFA number 7 of 2022. Facts in brief is that the LAC of the respondent number 5 has overlapped the LAC of the pro forma respondent. Hence, the respondent number 5 instituted the civil suit number 77 of 2018 against the state respondents, challenging the order dated 3/11/2017, issued by the respondent number 3, that is the Director of Revenue.
What is that? 311.
311 is, my lord, is the order issued by the Director of Revenue Department,
Regarding?
saying that overlapping of the lane of the pro forma respondent.
Respondent number 5's land
5 lane
has overlapped whose
has
land?
overlapped the pro forma respondent, my lord.
Pro forma respondent number?
Pro forma respondent of the present petition, my lord.
That is
Well, Remo,
respondent number
Respondent number 6, my lord.
6. Okay.
Yes, my lord.
Then so director has issued notice.
Yes, my lord. Then, during the pendency of the said suit, the respondent number 5 submitted application under section 151 of the CPC for transfer of location of his LSC from Punchong village to Zonwam village.
Yes. Where is the application?
The application is at page 39, my lord, Annex 2. Page 39 onwards.
Before that, where's the civil suit?
Civil suit is found
page
at
22.
20.
20 or 22?
my lord. Page
22.
22 is the plaint submitted by the
Respondent number
5.
What does he seek here in this plaint?
At page 35, the reliefs claimed by him is at para 26. I'm reading with lordship permission. That the plaintiff therefore prays for the following reliefs: for a degree in favor of the plaintiff and against the defendants. Number 2, for a degree declaring that the plaintiff is the rightful owner of the land covered by LSC number so-and-so, which is situated at Sakotui Chun, presently falling within the jurisdiction of Punchong Local Council, Aizawl. Number K, for a degree declaring that the LSC number 1890 of 2009 belonging to the defendant number 5 is null and void and is liable to be cancelled. Number L, for a degree declaring that the actions on the part of the defendant number 1 to 4 in issuing the LSC number so-and-so to the defendant number 5 and their actions in entertaining and considering the defunct expired House Pass number 1882 of 1990 for making out the said LSC number so-and-so is illegal and void ab initio, and to further declare such illegal actions and any other order passed in this respect by the defendant number 1 to 4 as null and void, and for setting aside and quashing such action. Number M, for setting aside and quashing the impugned order dated 3/11/2017, passed by the defendant number 3, and also the impugned verification report dated 19/6/2017, made by the Surveyor of Land Revenue and Settlement Department, Aizawl, in respect of the dispute between the land of the plaintiff and the defendant number 5. Number N, for permanent and perpetual injunction against the defendants, thereby restraining them from disturbing, interfering, issuing, and passing detrimental order against the plaintiff's land covered by LSC number so-and-so, and also from doing anything to detrimentally affect the interests of the plaintiff pertaining to his aforesaid land.
So defendant number 5 means the pro forma respondent number 6
Yes, my
in
lord.
this case.
Yes, my lord.
So while this civil suit was going on, then the plaintiff
application-
found some plot of land.
Subsequently, yes, my lord.
And he asked for a direction by filing 151 application that
Yes,
he asked
my
the revenue to direct the revenue to transfer the land.
Yes, my lord.
But that was earmarked, I mean, was already processed.
Applied by me. Yes, my lord.
Yes. So that is the story. So this is 22, then 39 is the application.
Yes, my lord.
Then comes the order.
Then order is after the index. This the page 1 is the judgment and order passed by the Lanet Senior District Judge, which we have filed before this first appellate court. Then the Senior Civil Judge order is found at page II.
So, Lianchama, this page 50 and 51, I think they should not be together.
50 and 51.
Or okay, this is the order.
Yes. This
50 is the order.
Order passed by the Lanet Senior Civil Judge.
Okay. Then what have you challenged here?
I have challenged both. The order passed by the district judge as well as the order passed by the senior civil judge.
Okay, after senior civil judge passed the order, you filed appeal.
File an appeal before the
Okay.
district judge. And the same was, I mean, to a certain extent, it was allowed, but remanding back and with an advice to file a civil suit
Civil suit against what?
as against the order. My lord, I'm reading the order passed by the district judge at page 3, my lord.
Just a minute, you just, page 3, right, the second last paragraph?
Second last paragraph. It would not be, the parties would agree.
Or you can read from the second paragraph, duly considered.
Yes, yes, my lord. Duly considered the submissions of the parties, it is the admitted position of the appellant that he was not a party to civil suit number 77 of 2018, and that no evidence was adduced in respect of the avowments presented in this appeal of his having had possession of the land, which was allotted by transfer to the respondent number 5. And it is undeniable that it would not be within the scope of Order 41, Rule 27, for the appellate court to take evidence in respect of those avowments made here at the first instance. The parties would agree that as the appellant herein was never a party to civil suit number 77 of 2018, the order dated 7/3/2022 passed therein by the Lanet court below would not bind him, and he would not be barred by the operation of res judicata to challenging the validity of the impugned order by way of a fresh suit. It would not be possible for this court to grant the appellant the relief prayed for of setting aside the impugned order dated 7/3/2022 in civil suit number 77 of 2018 in the absence of any supporting evidence. The appeal is accordingly dismissed with the observation that the appellant may file a fresh suit before the Lanet Civil Judge 4, Aizol, for declaration of his rights and title, if any, over the transferred land, if so advised. This is the order. My lord.
What is that provision you were saying under the Land Revenue Act?
Section 16, my lord. 16 of the Revenue Act. Section 16 of the Revenue Act. Allotment of land, my lord, at page 20.
Same book,
Same book, my lord.
page number?
20. Page 20. Page number is made
Yes.
down under, my lord.
Yes.
Allotment of land. The government is subject to the availability of land, free from all encumbrances, and subject to appropriate recommendation of the Site Allotment Advisory Board, as may be constituted by the government from time to time or in separate proceedings. The government may allot land belonging to the state government as declared under Section 12 of this Act to the eligible person or persons as described in subsection 16 of Section 2 or subsection 45 of Section 2 of this Act in accordance with such other conditions as prescribed in Chapter 4 2(6) of this Act. The director or the settlement officer or the assistant settlement officer, subject to appropriate recommendation of the Site Allotment Advisory Board, as may be constituted from time to time and with prior approval of the state government, shall have the power, number 1, to allot any such land for the purposes of any industry or shop or stall or stone quarry or for any purpose of public utility on such conditions as may be prescribed. Number B, to allot land beyond the maximum ceiling limit of 60 bighas or 80,268 square meters, subject to the recommendation of the Mizoram Public Investment Board in a special case and public interest, as the case may be. Or, number C, to entrust the management of any such land or any right therein in writing to the local council or the village council, as the case may be, for the purposes of supply reserves or any other public utility purposes for the related area as may be prescribed. Number 3, no allotment of land of any nature for whatever use shall be made in areas that may cause public nuisance or that it is not in general public interest on ground of public health, public safety, and even public convenience. My Lord, on going through the provision under Section 16, the Civil Code does not have any jurisdiction to make allotment of land to the applicant.
What they can do is, they can go by the order passed by the Civil Code, and since the provision of Section 16 is there,
My Lord.
they will refer to the Section 16 and see that whether there is any feasibility of allotting the land to this person.
My Lord.
And if it is found, they may allot. But if it is found that some process has already been made in respect of the present appellant,
My Lord.
so they can very well say that it's not feasible to allot the land because somebody has already, the file is already processed in favor of somebody else.
My Lord. My Lord. That is
That could be done.
right.
But since it's the court's order, they say that since the order has
They are
passed,
right, my
they are
Lord.
bound by this.
Yes, my Lord. And moreover, my Lord, there is no provision for location transfer under the Mizoram.
There's no
Revenue
location
Act.
transfer, but they do that.
They do. Yes, my Lord.
And no court can order the authority concerned to allot land.
My Lord.
He holds the rules. When law is
Right.
made, it has to be in compliance with the law.
Yes, my Lord.
In accordance with law, it has to be issued.
Yes, my Lord.
So although the civil code may have directed, but it cannot bypass the law.
Right, my Lord.
Law is there, that how it has to be issued. So they have to go strictly by that provision. There's no
Right.
shortcut.
Right, my Lord.
But the kind of understanding is that since there's a direction from the court, we have to give him.
Right, my Lord.
There's no other option.
Right, my Lord. Even if it is against the, the law in existence.
Mr. Bilara Menga, you are there for the
Yes, my Lord. I'm for the respondent number 5,
5.
who filed the civil suit, my Lord, at the trial court.
Oh, you're for the 5.
Yes, I'm for respondent number 5.
You had filed the application also, 151.
Yes, my Lord.
Okay.
I was
So what
the
do
one
you
who
say?
I was the one who filed the application
Ah.
by invoking inherent power, my Lord.
Correct, but you see, somebody has already applied for that plot of land. According to you, this is a vacant land, so you say that let them process the matter in my favor. But it so happens that somebody has already applied for that land and some process was on.
It was not yet allotted yet to him, my Lord. It was under application only.
Huh?
So he has no locus standi at all, my Lord. He applied and I also applied through filing of the application.
But the court direction says that allotted to you, transfer.
Yes, to transfer, yes.
How can that be done? How can that be done?
Then, being aggrieved, my Lord, the present appellant had filed the regular first appeal before the landed district judge. And by filing of the regular first appeal under Section 96 and Section 96 CPC as well as Section 17 of the Mizoram Civil Codes Act. And that was disposed of by saying that, my Lord, it would not be possible for the appellate court to grant the appellant the relief prayed by him, And thereafter, appeal was accordingly dismissed with the observation that appellant may file a fresh suit before the learned civil judge for declaration of his rights and title. So that was correctly advised.
No, who will file before the civil court?
May I take a lordship to page 3, just next to the index, my lord. This is the impugn order. Order impugned to the present appellant. It says that the present appellant may file a fresh suit before the learned civil judge for declaration of his rights, and if any, over the transferred land, if so advised.
Land is transferred already.
No, it was directed to be transferred, my lord, as per the order passed in that section 151 application.
But whether the court can pass such kind of direction? Transfer the land to somebody.
There is the bar of the civil court's jurisdiction.
Have you let any evidence that this is a vacant plot of land? I have taken the service of this surveyor. The revenue department also has cleared that this is a vacant plot of land, but still they're not processing it, so please direct. Anything like that?
No, my lord. However, from
You
the...
just, on your own, you have gone and identified one land. Oh, this is a vacant land. Next day, you apply 151 before the court, say that, make one direction that this should be given to me. The court said, okay, take it. That cannot be, because had no one come forward, then of course it would have just gone like that. But since somebody has come now, saying that, how come? I have already applied for this land, process is on. How did the court direct like that? And since he also was not a party to that case.
However, lordship,
You ought
there
to
was...
have made him a party, that see, this is your thing, but since the land has not been allotted in your name, I also have equal rights for that land. You have to put him to notice.
But
That was not there.
At the time of filing of the application under 151 CPC, it was not known to me that he also applied for that.
Now it's known to you.
Yes. Then he filed the appeal, my lord. Regular first appeal. And it was disposed of. And it was dismissed. Then the only option is that then he has to file the second appeal, if he is still aggrieved. This is not the correct way. Challenging in the two orders passed by the learned lower courts in the same civil revision petition. Then there is the correct provision, my lord. Filing of the second appeal is a must. Then it cannot be that, although this honorable court is having wide power under section 227, then correct provision is there under CPC, my lord. He should have approached that correct procedure first. He should have applied. And on the top of that, my lord, even at the time of taking up of that section 151 application by the learned trial court, the state defendants did not raise any objection. It was a vacant land, definitely.
They are not interested parties. Whoever it goes, Mr. XYZ, okay, fine, we'll process it. You pass the direction, we'll process it. That's what they say. But it's the individual who has claim over that land, although he may not have the title as such, any pass in his favor, but he has applied for that land.
And your lordship, moreover, this section 96 of the Mizoram Land Revenue Act 2013 says about exclusive jurisdiction of the revenue courts and bar of civil courts. And the particular, despite notwithstanding what have been mentioned in section 16, what the learned senior counsel has just read out, but this section 96, bar of the jurisdiction of civil court, doesn't specifically include transferring of the location, my lord.
Section 96.
Yes. By extending the inherent power, the civil court had, for the interest of justice, made such arrangement, because that particular land wasn't allotted yet to any other person.
Is the AC on? This side also. So what does this provision say, 96?
96 says about the bar of the jurisdiction of civil court, my lord.
So how is it relevant to this case?
The reason why I'm saying is the present issue is not included in this particular section 96 of the Mizoram Land Revenue Act 2013. That means the exercising his inherent power, its inherent power by the Honorable Learned Trial Court, then that can be, there is no bar under Mizoram Land Revenue Act 2013 to transfer, even to transfer the.
But is it not one-sided? Somebody files an application, he says, okay, take it. Because there's many things behind it. Now you have dragged out this case. You have pulled out Mr. Lianrima's case, client.
Yes, Your Lordship. He also
By applying
applied.
for that land, you thought it was empty land. Ultimately, it so turned out that it's not an empty land. Somebody, I mean, not, it's empty, no doubt, but somebody had already made a claim for
Yes.
that. The process was on.
Yes.
Now, because of that order, the revenue authorities are not doing anything. They say that there's an order of the court, we cannot give you anything like now.
Yes.
So ultimately, he has come before this court.
Yes, my lord, what I'm saying is, Your Lordship, what I'm submitting is that he also applied, he was applying at that time. And I also applied, although I did it through the trial court, and the order was passed in my favor. Then he challenged. Then that means we will be at the position of applying the land again. Then he was advised to file the civil suit because he hasn't obtained any title yet at the time of filing of the regular first appeal. Then the court, the Learned First Appellate Court dismissed the appeal. Then if he is still aggrieved, and if he is not aggrieved, then he should have filed as advised by the Learned First Appellate Court. The civil suit he has to file because he hasn't obtained any title yet. And if he is aggrieved, the only procedure he has to avail of is to file the second appeal, my lord.
Now, if you say that he doesn't have the right and title as of yet, how will he file the civil suit? On what basis?
Then, my lord, the First Appellate Court correctly advised that fresh suit for declaration of his rights, saying that I am applying this land, then I deserve it more than the present respondent number 5. Unless and until he files that kind of suit first, then how can he have that kind of locus standi, saying that as if he is the one who deserves better, my lord. Anyone can apply for the vacant land. And while looking at section 16 of the Land Revenue Act 2013 also,
Section?
16, prerequisite steps need to be taken, like regarding
On what basis you are seeking that that degree in that civil suit? On what basis?
decreeing the civil suit, my lord.
Yes,
I had a landed property duly covered by my own LSC,
yes.
and it was overlapped by the LSC of the defendant number 5, Srimati Rin Moi. And that is the reason why I filed the civil suit.
So why do you say that you have a better stand than the defendant number 5?
Because my
Why
lord,
should it be given to you?
my LSC was correctly issued by following all the correct procedures, and it should be upheld.
What was the stage of that civil suit when it was disposed of?
Now, it was, if I'm not mistaken,
Civil suit is disposed or not?
not yet, Your Lordship.
Not yet.
Yes, due to that section 151 application, now the proceeding had been stayed, kept in abeyance, and it went up to this honorable court.
Civil suit is still pending.
Still pending, my lord.
I see.
Now the issue has been diverted a little bit, my lord, due to that application filed by me.
Your LSC was issued in 2006
Yes, my lord.
and the defendant number 5,
Defendant number 5.
2009.
Yes, my lord.
So your LSC has overlapped his land or the defendant number's land, 5 land has overlapped your land?
But
Which way?
Defendant number 5's land, my lord, overlapped my LSC.
Because it was issued at a later point of time,
Yes, yes.
2009.
Yes, subsequently it was issued.
Then what happened? Why did you file civil suit? It should have been he who should have filed the civil suit.
My lord, the
There was some survey report.
revenue order is there, my lord, impugned revenue order.
Survey report you have challenged.
Yes,
That is against you.
yes, my lord. I'm sorry to say that annexes are not included here, so.
Mr. Liantrima, one pertinent question which Learned Counsel has raised is regarding,
My lord.
this is an order passed in the RFA.
My lord.
Should not be an appeal under section 100 be filed against that
No, my lord.
instead of 227?
In order to file a second appeal, my lord, we do not have any chance, because in order to file appeal under section 100, we need to have a base, foundation. We do not have any, because in the court of senior civil judge, we are not a party to it. And we have nothing to do with the civil suit number 77 of 2018. The only concern
Then why did you file the second appeal?
second appeal we have not filed. First appeal we
I'm
have
sorry,
filed.
first appeal.
It was filed by somebody else, my lord, in fact.
Maybe, but it was the same person.
It was filed by...
Counsel is different, but same person.
Right, my lord. Now, that is why we have challenged the two orders passed by the senior civil judge as well as the landed district judge. We have made a challenge to those two orders because
Okay.
of having no jurisdiction at all.
No, insofar as the civil judge is concerned, okay, but since this order was passed in the RFA,
My lord.
in the first appeal, so ordinarily it's the second appeal which lies against RFA. Why should we go for 227?
227, my lord. The only option we have, according to us, is 227. To rectify the mistake committed by the first appellate court and as well as the landed senior civil judge. Since they do not have any, the senior civil judge do not have any jurisdiction to entertain the application under section 151. So, under Article 227, my lord, as we can see from the provision, constitutional provision of the 227, Article 227, I'm reading with lots of permission. Article 227, every high court shall have superintendents over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction, my lord. So Article 227 can be invoked in the present case, since the lower court has overstepped, acted without having any jurisdiction.
Okay, that is in respect of the civil court.
My lord.
He could not issue that order because court cannot say that you issue the pass in that favor without there being any evidence.
My lord.
Okay, that part is okay. But what about the first appeal?
First appeal has upheld the order passed by the senior civil judge, which was considered to be without having any jurisdiction. So the two orders passed by the lower courts, my lord, are beyond jurisdiction. That is why we have come to a lordship under Article
See,
227.
after civil court, if you had come with 227, it's one thing. But before that, you had gone for RFA. RFA was denied, dismissed. So you come here not in RSA, but under 227.
My lord.
Whether that would be the proper procedure? This is one thing which needs to be clarified.
According to us, my lord, it is a proper step we have taken. We have no other option. And I'm having...
I think we need to have some more in-depth study on this
Well,
regarding whether RFA after RFA, one can go for 227,
My lord.
because this will have far-reaching consequences
Right, my lord.
in the long run.
I'm having one judgment in order passed by the Supreme Court, my lord.
What does it
I
say?
don't know whether it will help.
This is on 227.
Yes, my lord. I don't know whether it helps or not. I'm reading from paragraph 2, my lord.
Yes.
Feeling aggrieved and dissatisfied with the judgment, impugned judgment and order dated 25/4/2022, passed by the High Court of Judicature at Allahabad, dismissing the writ petition preferred by the appellants filed under Article 227 of the Constitution of India, challenging the order passed by the Learned Trial Court, dismissing the application under Order 6, Rule 17 CPC. The original revisionist has preferred the present appeal. By the impugned judgment and order, the High Court has dismissed the writ petition under Article 227 of the Constitution of India, observing that the writ petition under Article 227 of the Constitution of India is not maintainable as remedy by way of revision. Under Section 115, CPC is available to the appellants. As observed by this court in catena of decisions, and even in the decisions considered by the High Court, the view taken by this court is that where there is availability of remedy under Section 115 CPC normally, the petition under Article 227 of the Constitution of India would not lie. That does not mean that writ petition under Article 227 of the Constitution of India shall not be maintainable at all. There is a difference and distinction between the entertainability and maintainability. The remedy under Article 227 of the Constitution of India available is a constitutional remedy under the Constitution of India, which cannot be taken away. In a given case, the court may not exercise the power under Article 227 of the Constitution of India if the court is of the opinion that the aggrieved party has another efficacious remedy available under the CPC. However, to say that the writ petition under Article 227 of the Constitution of India shall not be maintainable at all is not tenable. Even other ways, it is required to be noted that even according to the High Court, the remedy available to the original plaintiffs was under Section 115 of the CPC. In that view of the matter, the High Court ought to have converted the writ petition under Article 227 of the Constitution of India into revision petition under Section 115 CPC, and ought to have considered the same in accordance with law and on its own merits, rather than permitting the writ petitioners to file a fresh revision application under Section 115 of the CPC. It would unnecessarily increase the burden of the court. To avoid further multiplicity, even the High Court ought to have converted the writ petition under Article 227 of the Constitution into revision under Section 115 of the CPC. In view of the above, for the reasons stated above, the present appeal succeeds. The impugned judgment and order passed by the High Court dismissing the writ petition under Article 227 of the Constitution of India on the ground that the same shall not be maintainable is hereby quashed and set aside. The matter is remanded to the High Court to consider the writ petition in accordance with law and on merits, for which we have not expressed anything on merits in favor of either parties.
But this does not answer the query.
Well,
This is regarding 115 and 227. So High Court said that since 115 remedy is available, you cannot file 227.
my lord.
Supreme Court says that maintainability and entertainability is a two different thing.
Yes, my lord.
So High Court could have exercised the discretion. Ordinarily 115 is filed, but when 227 is filed, the High Court could have just converted it.
My lord.
Instead of 227, they convert into 115 and entertain the application as 115. That was not done.
My lord.
So the Supreme Court has said that now we go back and this will be treated as 115. Court should do the necessary thing. But here's a case, we are talking about the second appeal and the first appeal. After that order passed by the civil court, entertaining the 151 CPC application and directing that location transfer, had you come straight away under 227, there's no issue.
Right, my
But you had gone for second appeal, first appeal.
First appeal, yes, my lord.
Appellate court said that, no, you file your own different suit if you want to. I cannot entertain this. So now the question is that there may have been some error committed, jurisdictional error by the lower court and affirmed by the lower appellate court. In such circumstance, without resorting to section 100, whether the High Court under 227 would still correct the error. Just have a look.
Right, my
Any
lord.
authority?
We can take up again on 7th April. No, during, in the meantime, we can take more in-depth studies and all.
Yes,
My
yes. And meantime, you also file your affidavit. Whatever you want to file, you file. Instruction. Mr. Benjamin Alklamana, learned government advocate, submits that he has just received the Paravise comments and he may be granted a week's time to file the counter affidavit. No prayer is allowed. List this matter again on 7th of April 2025. I'll not make any observation, but keep that in mind.
My lord, we'll do that.
Or should I make an observation? Not required.
My lord,
It's obliged.
obliged.
Because not only your case, later on somebody may come.
Right, my lord.
Instead of filing second appeal, everyone will come and jump on 227.
Definitely, my lord.
Then
This will set a
there has to
precedent,
be some distinction
Right.
drawn.
my lord, my lord.
Item number 4.
May I please, Your Lordship? My Lord,
Yes.
my Lord, in this case, my Lord, I may be allowed to file objection, my Lord.
What is this?
My
Criminal
Lord, this
petition?
criminal petition, my Lord,
Criminal petition for what?
for my Lord, quashing the my Lord, complaint filed by Union of India, my Lord, and the order of cognizance order by learned court below, my Lord.
This is the first time you are appearing.
My Lord, copy was served, my Lord, through my Lord, online, my Lord. Hereafter, I first time appear physically, my Lord.
Okay, file your objection. 7th?
7, no, my Lord, 7 I will file, my Lord, and 29, my Lord, April, my Lord.
You already have your dates. 7, then 29, then when else? Throughout the year I've got your dates.
My Lord, early, my Lord, I am traveling the other state also, Arunachal and Kohima
I know,
also.
we see you everywhere. He's a busy man. You see, Itanagar, you go to Itanagar, he's there. You go to Kohima, he's there. And he's in Guwahati also.
He's everywhere.
Okay, Mr. S.K. Mehdi, learned counsel, learned CGC,
Yes, my Lord.
appearing for the respondents,
Yes, ma'am.
submits that since this is the first time he's appearing physically in the matter, he may be given 4 weeks' time to file objection to the criminal petition. Mr. Joseph L. Rantle, learned counsel for the petition, has no objection. In view of above, list this matter on
29.
29th
April.
of April 2025. You will file your objection till when?
My Lord, I am trying to file, my Lord, 7th or 8th, my Lord, I will try, my Lord.
Okay,
Not required to, my Lord, mention, my Lord.
okay. The respondents, they'll file their objection on or before 11th of April 2025 with a copy to the other side. You so advised.
Item number 5 for orders.
My Lord, I have one item, my Lord, left over, my Lord, item order. Orders. Item 5, my Lord.
This is item 5.
Yes, my Lord. My appeal is already admitted, my Lord, in this case, my Lord. And LCR is also called for, my Lord.
As he has come?
Of course, this reflected the same, my Lord.
Yes, LCR is there.
My Lord,
So, what is this matter?
my Lord, is relating to, my Lord, this, the director, they pay the Solatium interest, my Lord, in damage suitcase, my Lord. Solatium interest, my Lord. So, my Lord, may I pray this matter may be fixed for hearing, my Lord, and paper book may be directed to prepare the registry, my lord.
Paper book means, is there any evidence? Any evidence?
My lord, some paper in Mizul, Varnigur also, my lord, 2-3 papers, my lord. If not required, my lord,
No, that's why I'm asking you, if there's any evidence. No evidence, it's just the judgment,
judgment, my lord, they are referring to judgment of the another.
damage suit.
Yes, my
So, damage suit was passed in whose favor?
Dear,
In favor of the plaintiff.
yes, my lord. But here, my lord, they impose director to, my lord, pay the Solatium interest, my lord. Solatium interest, my lord, and Solatium and interest to the, as per judgment, my lord.
See, Mr., why don't you submit one typed copy of the order? The impugn order, this,
I'll submit, my lord.
the font is too small, you see.
Yes, ma'am, yes, ma'am.
It's very difficult to
Yes,
read.
ma'am, yes. I'll submit, ma'am. Next.
If you can have a typed copy.
Yes, ma'am, definitely, ma'am.
No evidence was laid over.
No, my lord. Only on the basis of the judgment of the another court, my lord, this was.
What is the judgment of the other court?
Yes, my lord, it is, my lord. Page 31, my lord, annexure Z, my lord. But in that case, my lord, there is no direction to pay Solatium interest, my lord. Only to pay damage compensation, my lord.
Okay, this appeal is filed under 96.
Yes, my lord.
So where's the vernacular part? You're saying there's vernacular.
My lord, only it is not probably not required, my lord. One receipt, my lord, is there, my lord.
That you could have translated,
Yes, my lord.
isn't it?
Yes, my
I don't think paper book is required.
lord. Yes.
But why was the LCR called? This is the receipt. You already have a translation.
Yes, my lord.
Page 26, 26A is a translation. And annexure D. Okay. This is a typed copy, okay. Then who are the parties here?
My lord, my party, my friend is, my lord, this,
My lord, I'm for 3 to 5.
3 to 5.
1 and 2, my lord, is my lord.
Huh?
Government is 3 to 5 is, my lord.
No, Mr. Benjamin is there.
Yes, ma'am.
Okay, Benjamin is there for 3, 4, 5.
3, 4, and 5. Actually, my lord, this case has been taken up by Mrs. Linda. So she's on leave. She'll be
Okay.
joining on April, my lord.
What about 1 and 2?
I'm representing Malad.
Yes. What is your case?
My case is that I have received the compensation for crop damage.
Crop damage.
And
And now,
And
what,
after
what else remains?
the remaining portion is with regard to Solatium interest.
So direction was for Solatium interest.
Yes,
That you are supposed to get.
yes,
Have you contested the suit?
Yes, my lord.
yes.
What did you file? WS?
Before the,
You are the one who filed damage suit.
yes, my lord.
Okay. And to prove your damage suit, what evidence did you lead?
Only refer to judgment, my lord, this, my lord, main judgment.
How can that be?
Yes, ma'am. That is,
That judgment will be in respect of some damages done to some other land.
same, my lord, same, my lord.
Same land.
Same land.
Same amount of crops,
My lord,
same amount of same set of terrain.
my land,
How can that be same?
my judgment says, speaks, my lord.
Mr. Yangliana, how do you claim the damage suit without leading evidence?
My lord, with regard prior to filing of this damage suit, another damage suit was filed, wherein the judgment and order was also pronounced by the trial court.
Okay.
So we are also the landowners who are included in the earlier verification, but we are not included in the earlier suit. damage suit.
Okay, but the assessment cannot be same, isn't it?
Yes, the assessment can be,
The area of land, the variety of crops, trees, plants, they'll all differ.
that is different, yes.
So how can you be covered by that judgment? This is what I don't understand.
Because the Revenue Department had admitted that there was a genuine verification over my land. And that verification, by relying on that genuine verification report, the judgment order was passed.
We are not on the damage, my lord, we are on the Solatium in the interest, my lord. My lord, this page 39, my lord, this paragraph 3, my lord. Finally, three more courts did on hearing so and so. The plaintiff reiterated the instant case is covered case by the order that so and so in damage of 3 of 17, my lord, like this, my lord. Therefore, decision is paragraph 5.
You are aggrieved by which order?
My lord, this order, my lord, dated, my lord, judgment and order dated, my lord, this in page 35, my lord, this order dated 8 April 2022.
Okay, so come to page 41.
41, my lord. 41 is that.
Serial number 2.
Yes, my lord.
They are declared to receive compensation for the damages in crops in terms of the statement of assessment of compensation.
Yes, my lord.
Assessment already done.
Yes, my lord. The assessment done, my lord, only.
Okay, assessment was already done.
Only so far the direction to Solatium and interest, my lord.
Where is the direction for Solatium
My
interest?
lord, thereafter, my lord, this,
Which
two-
paragraph?
2 itself, my lord. To the annexer D the plaintiff as well as the Solatium, as well to the Solatium interest accruing thereof as per law.
So you are on the Solatium interest.
Solatium interest, my lord. This, my ground is also, my lord, this, it is there, my lord, ground, my lord. Ground of appeal, my lord, in this page 5, my lord.
So they are given, the assessment was made in respect of damage only, crops,
Damage, my lord.
not for acquisition of land.
Yes, damage paid, my lord. Damage was paid, my lord.
Okay. Damages assessed and damages paid. He also accepts that they have been paid. Now what remains is Solatium interest.
Solatium interest.
According to you,
Yes, sir.
Solatium interest cannot be paid
So far.
because it is not a case of land acquisition.
Yes, my lord.
It is only for assessment of damage.
Yes, my lord.
What is the law in this regard?
My law says, my lord, as per law, my section 23(1)(a) and 23(2), my lord, of 1918 and 94, my lord, only applicable land value of compensation, my lord.
Let us see. You also try to find out. I don't think it's a very complicated issue.
Yes,
Section 23.
23, my lord. 23(1)(a). In addition to the market value of the land as above provided, the court shall in every case award an amount calculated at a rate of 12% per annum on such market value of the period commencing so and so from the date of publication so and so, subsection so and so in respect of the land to which date of award of collector or the date of taking possession of land whichever is earlier. In addition to market value, the land above provided, the court shall in every case award an amount 30% on such market value considering the compulsory nature of acquisition. These are only relating to land value. Damage of the crop, there is no law.
Solatium is basically confined to section 23, 1A
1A,
and 1.2, 1A, 2,
1A,
and 2 also.
A2 also. Interest.
So, Mr. F. Lalengeliana, what do you say? They have no dispute regarding damages that you have
Yes, my
taken.
lord. Yes,
You have taken the damages already, isn't it?
yes, my lord.
Now, what they say is that court has made an observation that in addition, they should be given Solatium,
Yes,
in Solatium and interest thereof as per law. What is the law? Law is section 23(1)(a) and 2. It says, in addition to the market value of the land as provided, your land has not been acquired. Was it acquired?
It was acquired, my lord.
This land, my lord, not acquired. They have
Huh?
some portion of other land may required, my lord. This portion not.
Totally acquired, my lord.
How? By which award?
My lord, in that regard, the reason is that as the land was covered by the village council pass, so
Show me the award, whatever it may be. If you say it was acquired,
in the present appeal, my lord, there was no enclosure of the award.
you should have it. You are appearing for 1 and 2. You should be ready with all the papers. You're not ready.
Yes, the documents is with me today, my lord. So
Whether there is any document at all about the award
here,
in your favor, acquiring the land.
actual award is not available, my lord, but the sanction is reflected in the impugn judgment passed by the trial court, my lord.
Where?
It is available at page 32 of the present appeal petition, my lord.
32.
32, yes, my lord.
This
Here-
is,
This particular order pertains to the land of 9 genuine landowners. But
are you there in this case? Are you amongst these 9 genuine landowners?
out of the 11 landowners, I am included. But here it talks about 9 genuine landowners. But initially, when the verification was done, which is available at page 27 of this appeal petition. My name is at serial number 3 and 4, my lord.
Okay, whatever it may be, question again is whether any award has been given to you, compensation for acquisition of your land, or whether your land has been acquired or not. If the answer is yes, then there's nothing wrong with the Solatium interest order. If no, then this is against the Land Acquisition Act.
So far as the land is concerned, it is acquired through our own understanding. It is acquired.
Which land?
My
Where?
land.
By which award? Show us.
My lord, here, if I may read the,
There are just 2 petitioners. What is your land holding? What kind of pass do you have?
I am having village council pass, my lord.
Yeah, which one?
The village council pass, which is written in page 27,
Serial number?
serial number 3 and 4. Village
But
council,
I cannot make out serial 3 and 4. There are no numbers.
yes, it's.
What is his name?
difficult.
What are the names?
Lalruat Ralte and Lalram Lupui, my lord. That is serial number 3 and 4.
Dalruat
The number
Ralte
is
and
Lalram Lupui.
Taram Lupui. They are the respondent numbers,
Respondent number 1 and 2 in the.
1 and 2 in this case.
Yes,
Dalruata is 1,
yes, my lord.
and Lalram Lupui is respondent number 2. And this is your VC pass.
Yes, VC pass.
And what is this document? See, where is the column is blank. Area of land to be acquired, it's blank. Total value, blank. Building value, blank. Value of crops. You have got the value of
main-
crops, well and good.
My lord, the main reason is that the High Court during that relevant period made a decision that the persons having the village council pass are not entitled to receive any compensation.
Okay,
So, as the Honorable High Court made a decision in that regard, so the damage for crop was assessed in our favor, my lord.
so you have taken
only-
it.
Yes, we have taken the crop value only, instead of getting the land value,
Okay,
my lord.
so?
But in our opinion, when the market value is assessed, the market value also includes, my lord, in our humble opinion, the direct agricultural crops produced from arising out of our land, my lord.
Solatium will
So-
be included even if the land is not acquired. Is that
Yeah.
what you're saying?
Here, formally, the land might not be acquired formally by passing over, but our whole land is taken over, my lord. We cannot use the land also.
But how do you say that? It is not formally acquired, but they have taken over our land, and you're keeping quiet. This is not your appeal also. This is appeal by the Union of India. You are satisfied with the compensation received towards damages. You have no grievance at all.
According to us, my lord, in order to receive the Solatium and interest, my lord, though we are not receiving the land value, in order to define the market value, my lord, here, direct agricultural crops.
Market value of what?
Market value of the land.
Market value of your crops? Market value of the land will be assessed if your land is acquired. If your land is not acquired, what would be the reason to assess the market value of the land? For what purpose?
What I'm trying to say is that, my lord, though the land was not acquired formally, though we are receiving only the crop damage, we are entitled to receive the market value of the land by calculating direct agricultural crop, which is to be regarded as the market value, my lord.
Which is to be regarded as?
The market value of the land.
Market value of the
Because we are receiving the crop damage, we are receiving the compensation for crop damage. This is the direct agriculture crop arising out of the land. So, for determination of the market value, that is a relevant consideration as per the decision of the Apex
No,
Court
you should
also.
have taken steps accordingly. Your crops were destroyed by construction of what? Railway?
Railway, my lord.
Crops was destroyed, so for the crops you got the damage.
Yes, my lord, we paid, my lord. It was paid,
Ah.
and it was paid, my lord.
And land was not acquired. There's no material before the court which shows that your land was acquired. Your own document or the apportionment of the assessment shows that area of land, there's nothing, total value calculate nothing. So 23(1)A speaks about, in addition to the market value of the land, calculation of 12% per annum on such market value. So market value was not assessed anywhere. So how do you expect Solatium to be calculated when there is no market value at all? And why there is no market value? Because land was not acquired. Maybe they have dumped some earth spoils on your land, your crops were damaged, and for which you have been compensated. If your land was acquired, then definitely they'll have to invoke 23(1)A.
My lord, here, if I may read Annexure F of this appeal petition, my lord. This is the
Page?
page 30. Letter sent by the Undersecretary Revenue Department to the Deputy Commissioner of Police District.
Yes.
Here, I'll read the italic portion, my lord.
Yes.
The matter has been examined in the Law and Judicial Department and is hereby returned with an advice that the Law and Judicial still abide by its advice tendered earlier to the Deputy Commissioner of Police and that filing an appeal is the best course of action at this stage. Further, with regard to payment of compensation to those 11 genuine landowners, if the verification is binding in the eye of the government and if satisfied amount is available, then the amount may be paid thereof, because non-payment would be denial of right to those genuine landowners, which may attract unnecessary litigation.
What was examined here? We don't know what is examined.
This is, I'd like to specifically mentioned with regard to payment of the compensation to 11 genuine landowners. When it talks about 11 genuine landowners, we are the 11 genuine landowners, my lord.
How can they be?
who-
You are 2, you are not 11.
My lord,
When I say 11, my lord,
other damage
there
suit,
is
my lord,
earlier
other side.
damage suit.
Page 33, my lord,
We are
other-
having the
page 31,
same-
my lord, the order, my lord, the other genuine, landlord, page 32. Page 32 is 9, my lord. Page 33 is the order, my lord.
This,
This includes 9 of them.
Nine, my lord, and it is only given the damage compensation, my lord, page 32.
What is the assessment here in the chart at page 32?
My lord,
This is damage.
yes, my lord, damage only, my lord.
So similarly, petitioner,
Yes.
two of the landowners also here, they were given damage.
Yes, my lord. And and in judgment it also reflected the same, my lord. On the basis of the earlier judgment, my lord, this was.
These 9 persons, did they get any compensation for land?
no, not yet, my lord.
You are all similar.
Yes. we
You are all the same
similar.
boat.
Yes.
So
exactly.
9 have got the damages.
Yes, ma'am.
So applying the same principle, the 2 respondents, 1 and 2 have got the damage.
Yes, ma'am.
Fine. All of you have got the damage.
Yes, ma'am.
None of the 11 persons have got compensation for land. Because
Exactly.
land was not acquired. Market value not determined because land was not acquired. So the observation made by the learned trial court is something extra. Give them damages and also solatium in interest as per law. As per law. So if the law says that you cannot get solatium in interest, you cannot get. Matters as simple as that.
That is the main thing, yes.
And
You have not pressed that, okay, VC pass, but I should also get land value. You should have filed appropriate application seeking for land value. You have not done that.
their names were not in award, my lord. And page 38, my lord, paragraph 4, my lord.
38.
Plaintiff is not included in the award list as per spot verification report, so and so.
38.
38, my lord, paragraph 4, my lord, what is,
Oh, it's very difficult to read.
yes, my lord.
We don't have such good eyesight like you, Mr. Mehdi.
My also same, my lord.
Make sure you print big ones.
Here,
This is too minute, otherwise you have to give us some reading glass, magnifying glass.
next time I'll try to type out, my lord.
Bring one magnifying glass from Guwahati, next time. So, I think the matter ends there, Mr.
Yes.
Efla Liangliana. Solatium in interest cannot be given like that.
In that regard, my lord, time may be given for arguing that.
Time for what?
Time for,
How can you bring in something which is not there in the judgment? Mind you, this is not your appeal. This is appeal by the Union of India. You cannot file counter affidavit also. This is RFA. We have to argue on the materials available on record. Original
I know.
record is here. Is there any assessment in the record showing that your land value has been assessed this much and you have not been given? There's no assessment. You are basically making your claim on the strength of the observation made by the learned trial court saying that they should be given solatium in interest as per law. But when your land is not acquired, land value not determined, only damages determined, you receive damage but not solatium interest. You cannot receive solatium interest, just like that. Your submission is that since the market value would have an effect on the solatium, so we should also get that benefit. I don't think that is the correct position. Unless you can show me one authority saying that although land is not acquired, if damage is also given, then solatium interest should be included. All right, we
That
close
is-
the matter. We'll close the matter.
Yes.
I heard Mr. S.K. Mehdi, learned CGC for the appellants, and Mr. F. Liangliana, learned counsel for respondent number 1 and 2, and Mr. Benjamin Lathamwana for the remaining respondents. So by filing this appeal, the appellants have challenged the judgment dated 8/4/2022, passed by the Court of Senior Civil Judge, Colosseum District, Mizoram, in damage suit number 1 of 2018. Full stop. Mr. S.K. Mehdi, Learned Counsel, Learned CGC, submits that the Learned Trial Court has passed the impugn order on the strength of the judgment, on the strength of the order passed by where's the beginning?
Well,
Of page 31?
my lord, it is reflected in page 33, my lord, with the present MS suit 3 of 2017 stand dispose of, my lord. Last line, with this.
Passed by the predecessor court of Senior Civil Judge Colosseum in damage suit number 3 of 2017, whereby as many as 9 persons who had filed the damage suit were directed to be paid the damage compensation as assessed by the collector. Since their lands were damaged due to construction of railway line by the NF Railway. Stop. Since the respondent numbers 1 and 2 in the instant appeal were also among the listed persons numbering 11, for whom the assessment for damages was made, the Learned Trial Court directed that the amount so assessed towards damages should be paid to them through the impugn order dated 8/4/2022. To stop, the Learned CGC submits that insofar as the payment of damage is concerned, the appellant has no grievance, but it is the direction given by the trial court towards payment of solatium and interest that the appellant is aggrieved with. Stop. Referring to section 23, bracket 1, capital A of the Land Acquisition Act, 1894, bracket LA Act, close bracket, the Learned Counsel submits that solatium and interest would be only payable for acquisition of land upon determination of the market value at the rate of 12% per annum of the said market value. Stop. In the instant case, since the land of the petitioner, the land of the respondent numbers 1 and 2 were not acquired, there is no question of payment of solatium and interest to them. Next para, Mr. F. Lalengliana, Learned Counsel for respondent numbers 1 and 2, on the other hand, submits that the amount of damages assessed by the collector has duly been paid to the respondent numbers 1 and 2. But however, in addition, they would be also entitled to solatium and interest as directed by the Learned Trial Court. Full stop. He submits that since the land of the respondent numbers 1 and 2 has been affected by the construction made by the appellants, the market value for which the damages have been caused will have to be calculated so as to arrive at the amount of solatium and interest payable to the respondent numbers 1 and 2. Full stop. What is the submission, Mr. Benjamin?
Actually, as I've already mentioned, this case has been taken up by Ms. Linda, who is on leave, my lord. So,
They are respondent numbers.
3825, my lord. 3825.
Mr. Benjamin Latlamona, learned government advocate, submits that the matter is being handled by Ms. Linda L. Fumble, learned additional advocate general. And therefore, the brief is not with him. Full stop. Next para. There is no dispute to the fact that the amount of damages assessed by the district collector has been paid to the respondent numbers 1 and 2. And what remains is with regard to payment of solatium and interest. Full stop. Section 23, bracket 1, capital A of the LA Act provides as follows. Please abstract this, okay? A to A. You just add one more thing. Section 1A and bracket 2. A to A, page 60, okay? It's a yellow flag. Next para, from the above abstract, it may be seen that in order to be entitled to be paid interest there is a requirement of determining the market value of the land. First up, a perusal of the assessment report annexed to the appeal at page 27 does not reveal that any area of land belonging to the persons named in the said list, including the respondent number 1 and 2, have been acquired and assessed. Stop. There is neither an assessment for the value of the land in question, including the building standing thereon, except for the value of crops. Full stop. It is not even the case of the respondent numbers 1 and 2 that aggrieved with the assessment and aggrieved with the non-assessment of the land to be acquired. They had taken recourse to some process as permissible in law. Full stop. Therefore, the assessment so made only appears to be final. Full stop. Full stop. The above abstract would also go to show that unless there has been acquisition of the land by determination of market value of the land for payment of compensation, there would be no question of granting such solatium in interest. Full stop. Therefore, the observation and direction made by the learned trial court in the impugned judgment and order insofar as relates to payment of solatium interest is wholly misconceived, and accordingly the same is hereby set aside. Full stop. In other words, the impugned judgment and order dated 8/4/2022 passed in damage suit number 1 of 2018 insofar as payment of solatium and interest is concerned, it stands interfered with. Full stop. The appeal accordingly stands disposed of. Yes, one more line. The registry shall send back the original LCR. Yes. So we'll take a short break and come back. Okay.
hearing. Item number 6.
May it please Your Lordship, I am appearing on behalf of the state respondents. Your Lordship, when the matter was last listed on the 28th of February, and Your Lordship, it is from my end, from the AG's office, we are unable to track the file, so it has to be reconstructed, Your Lordship.
What has to be reconstructed? Your file.
Yes, Your Lordship.
So how much time?
Your Lordship, if 4 weeks may be granted.
Yes, what do you say?
Appearing on behalf of Senior Counsel Mr. Silaram.
What is your submission?
I have no objection.
Please write down. The case record of civil suit number 7 of 2007 has been received from the CJM cum Civil Judge, Senior Division, Longklai. Stop. Ms. Lalnun Louis, Learned Government Advocate, submits that she may be given some time. She may be given 4 weeks' time to reconstruct her brief, since the papers have been misplaced. Stop. Mr.
Stephen Watsaya.
Stephen Lal Botsai, Learned Counsel for the appellant, has no objection to the prayer. Next para. What about the CADC? Any response? Next para. On 28/2/2025, this court had directed issuance of notice to the CADC, represented by its Chief Executive Member, Kamala Nagar, Chongte C, Mizoram, by registered post with AD due. But it appears that AD card has not been received back till date. The Stop Office shall therefore track the postal consignment and put up a report by the next date. Stop, having regard to the fact that the matter has come back on remand from the Supreme Court, requesting the court to asking this court to dispose of the appeal expeditiously. 3 weeks' time is granted to the state respondents. No, 3 weeks' time is granted to the Learned Government Advocate representing the state respondents to reconstruct the brief. List the matter again after 3 weeks on a date to be fixed by the registry.
Much obliged, Lordship.
Item number 7.
Lordship.
Yes.
Lordship, this is regarding the RFA. It was part hardy, Lordship. And Lordship, may I take Lordship to page 142, the paper book, Lordship.
Just a minute.
Sure, Lordship.
142.
142, Lordship, the issues framed by the learned trial court. For a quick recap, Lordship. Since, at paragraph number 6, Lordship, the learned trial court had framed as many as 3 issues. Hence, considering the pleadings of both the parties, the following issues are framed and amended from time to time under the provision of Order 14, Rule 5 of the CPC. Lordship, herein the learned trial court had framed the 3 issues, and number 1 is whether the written statement counterclaim filed by the defendant counterclaim is maintainable or not. Lordship, the decision is at paragraph number 8. Lordship, issue number 1. Admittedly, the present written statement cum counterclaim has been filed by the defendant challenging the issuance of heirship certificate number such and such in favor of the plaintiff via order such and such issued by Senior Civil Judge Lunglei District Court, Order 4, Rule 1 of the CPC 1908 prescribed mandatory provision for institution of suits which reads thus: number 1, suit to be commenced by the plaintiff. Number 1, every suit shall be instituted by presenting a plain in duplicate to the court or such officer as it appoints in this behalf. Number 2, every plain shall comply with the rules contained in Order 6, Rule 7, so far as they are applicable. Number 3, the plain shall not be deemed to be duly instituted unless it complies with the requirements specified in sub-rules 1 and 2. Order 6, Rule 14 of the CPC, parties are mandate to append their signature in the pleadings, which read as 14, pleadings to be signed. Every pleading shall be signed by the party and his pleader, if any, provided that when a party pleading is, by reason of absence or other good cause, unable to sign the pleadings, it may be signed by any person duly authorized by him to sign the same or to sue or defend on his behalf. In the present case, defendant counterclaimant fails to comply with mandatory provision under Order 4, Rule 1 as well as Order 6, Rule 14 of the CPC, that neither she nor her learned counsel have given their signature in the pleadings. Paragraph number 11, that is the findings. Hence, consequence upon failure to comply with mandatory provisions under Order 6, Rule 14, as well as Order 4, Rule 1 of the CPC, and with the Honorable Apex Court decision in this, Court is of the considered opinion that the present written statement counterclaim is not maintainable. In the result, the present issue is decided in a negative. Lordship, the learned trial court had rejected the written statement counterclaim submitted by the appellant before the learned trial court, and Lordship, there is no chance to pass any order in favor of the appellant. Lordship, and at best, the appellant can get the trial court order for rejecting the heirship application submitted by the respondent herein. Lordship, so that is the reason why that CSS Conduct Rules 1956 and Form 7 pertaining to group insurance scheme 1992, it's not come into the picture, Lordship, because that was outside the issues framed by the learned trial court, Lordship. So my learned friend had said that that was not considered before the learned trial court, but Lordship, there is no reason to consider that pleadings, Lordship, because the WS cum counterclaim was rightly rejected by the learned trial court. And regarding this, Lordship, I take Lordship to one Supreme Court citation, 2012 5 SCC 756, 2012 5 SCC 756, paragraph number Lordship 13. Paragraph number 13, Lordship. A suit can be instituted by presentation of the plain, and orders 4 and 7 CPC deals with the presentation of the plain and the contents of the plain. Chapter 1 of the Civil Rules of Practice deals with the form of a plain, when the statutory provision clearly says as to how the suit has to be instituted. It can be instituted only in that manner alone and no other matter. The Trust Act contains 9 chapters. Chapter 6 deals with the rights and liabilities of the beneficiaries, which would indicate that the beneficiaries of the trust have been given various rights, and those rights are enforceable under the law. Section 59 of the Act confers a right upon the beneficiaries to sue for execution of the trust, which would indicate that the beneficiaries may institute a suit for execution of the trust. Therefore, the above mentioned provisions would show that in order to execute the trust, the right is only to file a suit and not any original petition. The reason why I read out this Supreme Court citation is that when the statutory provision clearly says as how the suit has to be instituted, it can be instituted only in that manner alone and no other matter. So the orders which I have read out, Order 6 Rule 14 clearly says that how to file a suit, then that has to be signed by the pleader or the parties, and that was missing. So the learned trial court had rightly rejected the written statement counterclaim. So there is no chance to pass any order in favor of the applicant, appellant here in Lordship. And Lordship, regarding the issue number 2, which is at page 142 again, Lordship.
Yes.
Issue number 2 is which one, the plaintiff or the defendant counterclaimant, is the legal and rightful wife of the deceased Thang Hing Lova. Who is the legal and rightful wife of the deceased Thang Hing Lova, Lordship? And Lordship, the relevant person is at page 148, paragraph number 25, Lordship. That is the findings. 148, paragraph number 25. May I read, Lordship?
Yes.
In the present case, both the plaintiff, petitioner, and the defendant counterclaimant has claimed that at the relevant point of time, they had married the deceased Thang Hing Lova in accordance with the Mizo customary law, Manhlan, and claimed to be the legal and rightful wife. In support of her claim, the plaintiff petitioner exhibited the marriage registration certificate as Exhibit P3, Manhlanna as Exhibit P4, family ration card as Exhibit P5, voter's ID of herself as Exhibit P6, voter's ID of the deceased Thang Hing Lova as Exhibit P7, and her Aadhaar card as Exhibit P8. Whereas the defendant counterclaimant exhibit her written statement counterclaim as Exhibit D1, her signature in the verification part as Exhibit D1A, her signature in the affidavit as Exhibit D1B, death certificate of deceased Exhibit D2, copy of the maintenance order passed by JMFC Aizol as Exhibit D6. On careful examination of the available evidence on records with documents exhibited by both the parties, it is evident of the plaintiff that she had married Thang Hing Lova on 4th June 2011, and bride price was paid, and the said Manhlanna is exhibited as Exhibit P4. That their marriage was Mizoram Compulsory Registration of Marriage Act 2007, Exhibit P3, and they were living as husband and wife and living in the same house, number 12 of Luang Mua Lung Le. Being husband and wife, she had reflected the name of Tan Hing Lo as husband in all her documents like family ration card, voter's ID, Aadhaar card. On careful analysis of the said Manhlanna Exhibit P4, it is written in vernacular language and reproduced as Manhlanna vo in date nili tharuk sang ni som pakat inrin ni hian Tan Hing Lo Vasha Selson of Tan Chinga Lunglon le Vanal Pari Dotrov Darbuk late in ne namhan cheng zali somni kadonga cheng zangni cheng somni thutpa atan kir ani the witnesses are there. And Lordship, at para number 27, on the basis of the Exhibit P4, the bride price was paid on 4/6/2011 by T. Lalthan Chunga and received by K. Lalramoya in the presence of Tlan Loma and R. Rual Kuma, the then President of Young Mizo Association, Wayame, and Village Council, Luang Mua Lung Le. Further, on the basis of evidence adduced by Rual Kuma as PW number 2, he was personally present during the time of Manhlanna between the applicant and her husband, Tan Hing Lova, but he did not bring his seal, and due to this, he gave his signature and put his seal on 05/06/2011, and he has exhibited his seal and signature as Exhibit P1A. Further, that on the basis of another documents exhibited by the plaintiff like marriage certificate, family ration card, voter's ID, Aadhaar card, name of the deceased Tan Hing Lova is reflected as husband of the plaintiff. Lordship, that PW number 2 had put his signature on the very next day, but it was exhibited without any objection from the appellant before the learned trial court. Lordship. At paragraph number 28, whereas the evidence of the defendant is that she got married to the deceased Street Tan Hing Lova in accordance with the Mizo customary law, Manhlanna, and they were living as husband and wife and had 3 children in the wedlock. That as her husband had acute alcoholic dependency problems, they used to have innumerable fights and disagreement, and finally she had left him and lived separately with children. However, there was no judicial separation or any form of separation in accordance with the Mizo customary law, and that her deceased husband continued to provide maintenance to her in accordance with the court order dated such and such, passed in the provide maintenance to her in accordance with the court order dated 21/03/2011, passed in criminal complaint number such and such, that before the death of her husband, they began to live together as husband and wife, that the applicant was not even present when he was sick and at the time of the funeral of her deceased husband, and that she was the one who took care of him, and the death certificate was issued to her. In support of her case, the defendant exhibited a number of documents like her written statement cum counterclaim as Exhibit D1, her signature in verification and affidavit Exhibit D1A and D1B, death certificate of the deceased, Exhibit D2, maintenance order passed by JMFC, Aizol Exhibit D6, copy of will Exhibit D9, probate order passed by civil judge Aizol as Exhibit D10. On careful examination of documents exhibited by the defendant, like maintenance order passed by the court of JMFC as well as Exhibit D6 and probate order as Exhibit D10, it is found that both the court orders were an ex parte order in which no defendants has contested both the cases, wherein para number 2 of the maintenance order by JMFC, Aizol order dated 21/03/2011 read as, the respondent did not attend this court dates even once despite receiving all the summons issued to him and despite being fully aware of the existence of the present case. This application was filed on 24/8/2009, and since the respondent has never appeared in court till date, his continuous absence is thereby taken as a willful negligence on the part, and accordingly this case is heard and determined ex parte. On the plain reading of the court order as extracted above, it is evident that the present defendant has filed criminal complaint under 125 of the CRPC 1908 against the deceased Tan Hing Lova on 24/08/2009, and all the summons issued to him were received, and he was fully aware of the existence of the case against him. That after almost 2 years, the concerned court decided to proceed the case ex parte since the defendant Tan Hing Lova willfully neglected to contest the case. However, in the present case, both the defendant and counterclaimant have claimed that they were getting married with the deceased Tan Hing Lova in accordance with Mizo customary law. Lordship, my learned friend had stated that based on this JMFC order in maintenance, it proves that the appellant was the legal wife of the deceased. However, Lordship, there is a Supreme Court citation which says that proof of the marriage should not be a precondition for maintenance under 125 of the CRPC. May I take Lordship to 1991 2 SCC, 1991 2 SCC, page 375. Page 375, paragraph number 3, Lordship. This is regarding 125 CRPC.
Paragraph?
Paragraph 3. Paragraph number 2, let's see.
Yes.
Section 125 of the CRPC is meant to achieve a social purpose. The object is to prevent vagrancy and destitution. It provides a speedy remedy for the supply of food, clothing, and shelter to the deserted wife. When an attempt is made by the husband to negative the claim of the neglected wife, depicting her as a keep mistress on the species plea that he was already married, the court would insist on strict proof of the earlier marriage. The term wife in section 125 of the CRPC includes a woman who has been divorced by a husband or who has obtained a divorce from her husband and has not remarried. The woman not having a legal status of a wife is thus brought within the inclusive definition of the term wife, consistent with the objective. The woman not having a legal status of the wife is thus brought within the inclusive definition of the term wife, consistent with the objective. And that is the reason why I read out. And Your Lordship, though 125 CRPC was granted in favor of this appellant, but it does not mean that the appellant was the legal wife of my husband, Your Lordship. And the appellant is not having any legal status of a wife, Lordship. Though it was granted in her favor, but there is no legal status of wife, Your Lordship. And Your Lordship, another citation, which is 2011 1 SCC 2011 1 SCC, page 141, paragraph number 42.
This is regarding?
This is regarding 125, Your Lordship. 125 of the CRPC. Page 4, paragraph 42. We are of the opinion that a broad and expansive interpretation should be given to the term wife to include even those cases where a man and woman have been living together as husband and wife for a reasonably long period of time, and strict proof of marriage should not be a precondition for maintenance under Section 125 CRPC, so as to fulfill the true spirit and essence of the beneficial provision of maintenance under Section 125. We also believe that such an interpretation would be a just application of the principle enshrined in the preamble to our Constitution, namely social justice and upholding the dignity of the individual. Lordship, here it says that strict proof of marriage should not be a precondition for maintenance under 125 CRPC. Lordship. And may I take back Lordship to the paper book, page 151, Your Lordship. Page 151.
See, before you
Lordship, yes.
bring us back to that judgment, the finding of the learned trial court was that there has been non-compliance of Order 6 Rule 14,
Yes, Your Lordship.
which is regarding signing of the documents,
Yes, Your Lordship.
signing of the plaint.
Yes, Your Lordship.
Then what is this signature here then? Page 50?
Page.
This is in the written statement counterclaim.
Yes, Lordship. Page 30.
Page 50.
50. Lordship, yes.
This is signatures by the appellant.
Lordship, page 49. I think page 49. Is it
49.
Yes, Lordship.
No, 50 it is there, 51 also is there, affidavit and the verification.
Lordship, yes. That is true.
Is there a specific prescription that it has to be signed in the plaint itself also?
Lordship, as per this, the findings and the CPC, it says that it should be signed by the pleader or the litigant, Your Lordship.
Let us see Order 6 Rule 14.
6 rule. So, pleadings to be signed. So, every pleading shall be signed by the party and his pleader, if any, Your Lordship. Provided where a party pleading is by reason of absence or any other goods unable to sign, it may be signed by any person duly authorized by him to sign the same or to sue or defense on his behalf, Lordship. Since I have relying on the Apex Court judgment, in Lordship, which I've already read out, 2012-5 SCC, it clearly says that when the statutory provision clearly says as to how the suit has to be instituted, it can be instituted only in that manner alone and no other manner, Lordship. And the learned trial court also relying upon that judgment itself.
So signing of pleadings, it means will not be complete even if the verification is signed or the affidavit is signed.
Lordship, this is a curative one, but Your Lordship, that has to be cured during the proceeding of the case, Your Lordship. The appellant has a sufficient chance to cure the defect made by themselves, but that was not done on their part, Your Lordship. So the learned trial court came into the conclusion that the mandatory provision, which clearly says that has to be signed, it shall be signed by the pleader or the litigants, it's a party. And because of the reason, the written statement cum counterclaim was rejected, Your Lordship.
Okay. So you were referring to page 150?
150, Lordship, yes. Yes, Lordship, page 150, 151, Lordship, sorry, 151. Paragraph number 31, Lordship. However, in the present case, both the plaintiff and the defendant counterclaimant have claimed that they were getting married with the deceased Than Hing Lova in accordance with the Mizo customary law Manhlana, and therefore, while careful consideration about this case, this court carefully perused the Mizo customary law Mizo Namdan, which was published in the Mizoram Gazette Extraordinary number such and such, as if wherein subclose that Your Lordship Mizo Namdan Bung Tuna, Lordship, it's in vernacular language.
You need not read all these.
Lordship, yes.
You just point out the relevant provision, that's all.
Lordship, yes. This number 1, Chang Somthum Pakat in Nei Chung Chang number 1, Lordship. In Nei Nupa, Mei Chia Le Mipa, Puitling, Nupui Pasal Pomlai Nei Lo Veve, Palai Manga Mipa Chung Tele Meche Chung Te in Berema, Man in Lana, in Nei Tir Tei Tu in, An in Nei Tir in Nei, Anni A, Chutiang Chok Chunupa Anni. Note number 1, in Nei Nahi Nule Pate Veve in Biak Remna Sa Coin Anem Het Chin Ani. In Nei Tir Tei Tu, Sorkar in Emo, to Nei Tu in Emo, Arwat Apiang, in Nei Tir Tu Anni. Lordship,
You need not read the provision. I just want to know the finding, that's all.
Lordship, yes.
Provision is there, not
Provision
required
is
to
the
be read.
Lordship, yes. Lordship, at page 153, Lordship.
Yes,
Paragraph number 33, yes. In the present case, both the plaintiff and the defendant claimant have claimed that they were getting married with the deceased Tan Hing Lova at the relevant point of time, that in support of her case, the plaintiff exhibit Man Lanna as exhibit P4 and marriage certificate issued by the marriage register of the local area, Luang Mall, exhibit P3, while the defendant counterclaimant fails to exhibit any marriage certificate or Man Lanna in order to establish that her marriage to the deceased Tan Hing Lova was actually solemnized and regularized in accordance with the Mizo customary law or any other law for the time being in force. In fact, documents exhibited by the plaintiff like family ration card, voter's ID, Aadhaar card are official documents used to prove the identity and address of the card holder in various schemes under Government of India and Government of Mizoram as well. Further, in view of the maintenance order passed by the JMFC, order says and such, it is well known that no wife had never claimed maintenance allowance from their husband under the provision of Section 125 CRPC as long as they are still living as husband and wife. But the said provision is usually put in motion in order to maintain destitute women and children who were neglected and refused to maintain and look after by their ex-husband or father. And with regards to the defendant counterclaimant's submission that the parties were once again living as husband and wife, and the defendant took the dead body of the deceased in her residence for funeral, and death certificate was issued to the defendant counterclaimant, does not prove that they were married in accordance with the Mizo customary law. In the result, on the basis of discussion, findings, and reasons as stated above, this court is of the considered opinion that the plaintiff is the legal and rightful wife of the deceased Tan Hing Lova, and the present issue is decided in favor of the plaintiff. Lordship. So, Lordship, as since there are as many as 3 issues, and it was decided, all of them are decided in favor of the plaintiff, who is the respondent here in Lordship. So, interference of this court is not necessary, Lordship. And regarding the alleged will, which was later probated ex parte, Lordship, and the respondent came to know the said alleged will dated 03/05/2016, Lordship. That was at page 65, Lordship. Page 65. Yes, that is. And later it was allegedly probated and ex parte. Lordship, in this regard, this heirship application was filed in the year 2017. Lordship, this particular heirship certificate was filed in the year 2017, and this during the pendency of this heirship application, probate case was filed in the year 2018, Your Lordship. So at page 66, it was written clearly, probate application number 16 of 2018. 16 of 2018. Without impleading the respondent as a, Lordship, the opposite party, the appellant clearly knows that there will be an objection from the present respondent, Lordship. So the intention of the appellant is very clear. Lordship, this has been in the Aizawl Judicial District, and the respondent is from the Lunglei. Lordship. And besides that, there is a will which was in favor of the respondent, which is at page 36, Your Lordship. Which is exhibited without any objection before the learned trial court, Your Lordship. Page 36, Your Lordship. And the original is in the record, Your Lordship. Court's record, page 36. It is exhibit P11 for the trial court without any objection, Your Lordship. So here it says that I, Than Hing Lova, son of such and such, AAI Agriculture Department of Mizoram, have decided to draft my final will on this day, the 22nd June 2013, as mentioned below. My wife, F. Vanalpari, daughter of such and such, will inherit everything that I own, and she will look after it as she please, as no one else except my wife Vanalpari looks after me during my hour of need, and also in times of my ill health. She will be the sole heir to all my pension benefits, including family pension. In case I happen to pass away overnight, no one should trouble her in this regard. This final will of mine will supersede all the other nomination that I have mentioned in my service book, and this is my decision. And that was executed on 29/6/2013. Lordship. And moreover, Lordship, I take Lordship to page 34.
Yes, 34.
This is the order passed by the Judicial Magistrate First Class 2, Aizawl District.
Regarding
This is regarding the
criminal complaint.
yes, criminal complaint. And here in the my deceased husband clearly stated that I am the a present wife, Lordship, which is at page 35, Lordship, the operative. Page 35, paragraph number 7.
Yes.
Lordship, paragraph number 7. There is a heated discussion, between the between me and the son of my husband, Lordship. So all the person except Than Hing Lova was sent out of the court. Than Hing Lova stated that his physical and mental is fit to use his conscience. He could answer all the questions put to him by this court rationally. He states that he loves both his present wife and his children. However, both hate each other. He is a government servant almost attaining the age of 60 years. He also states that he was admitted into the rescue home with his consent. Here it says that he loves both his present wife is me, and his children, Your Lordship. So the name of the appellant is nowhere mentioned in the order also, Lordship.
What about the rest of the sentence?
Lordship, yes.
He also states that he was admitted into the said rescue home with his consent.
Yes, Your Lordship. That was admitted by the son of my husband, Your Lordship. That was also forcefully.
Otherwise, your case is that he was taken forcefully from Lungle and brought here,
Yes, Lordship.
isn't it? He says that I have come here with my own consent. Yes.
And Lordship, besides that, since my learned friend had trying to rely upon the CSS conduct rules 1956, because those CSS conduct rules and that form number 7 pertaining to group insurance scheme, this is out of the issues framed in the learned trial code. So the learned trial code is not able to go beyond the issues framed by itself, Lordship. So as per the 3 issues framed by the learned trial code, no interference of this honorable code is warranted, Lordship. So this appeal may be rejected, Lordship.
Can you show me the original issues frame?
Issues, Lordship, yes.
The original issue frame.
Yes, Lordship. Which is at page 102 of the paper book.
What is the difference between the original and the subsequent one?
Lordship, as per my humble understanding, this issues was framed when the application for the heirship was filed, because maybe during that time no counterclaim was made, and later on, when the heirship was issued, was it 102 and 142? Was it? Number 1, at 102, the original one is whether the plaintiff is the legal wife of the deceased. Because the name of the counterclaimant, the appellant, is not in the picture.
Then number 2?
102. Number 2, whether the plaintiff defendant is entitled to receive the family pension and leave salary of the deceased Than Hing Lova. The counterclaim is not. And number 3, whether there is any document proof of the plaintiff to show that she is the legal wife of the deceased.
So this was on which date?
This was on, it's month is there? Or 27/6/2019. Yes, Your Lordship, it was signed there in the bottom, Your Lordship. 27/6/2019.
And the the counterclaim was filed on?
Was filed
After that?
in the year 2019, as per my report, Lordship. Here it's there. Page 30. Oh, 14/9/2019. Page 30, page 70.
Isn't it?
It was filed on 14/6/2019. Yes, 14/6. 102. 14/6. That original issues was framed after submission of this counterclaim, Your Lordship.
Okay, so we'll assemble at 2 again.
Lordship,
Yes.
Lordship, regarding the two issues framed by the learned trial court on different dates, Your Lordship. One is at page 102 and another is at page 142, which I've already read out, Lordship. If Your Lordship is not satisfied with that, Your Lordship, there is a provision under the CPC, Your Lordship, Order 41, Rule 23, Lordship. Lordship, 102, because there
Just
are
a minute. Issues are framed at 102
102, which is on 27/6/2019,
and the other one?
and the other is at page 142. Lordship, these issues, it
This
seems
is the
that
judgment.
yes, time of judgment. So, because of these two issues, Your Lordship may things not proper, then there is a provision under the CPC, Lordship, Order 41, Rule 23. Lordship. I take Lordship to the CPC, Order 41, Rule 23. Order 41, Rule 23.
Yes.
Remand of case by appellate court. Where the court from whose decree an appeal is preferred had disposed of the suit upon the preliminary point and the decree is reversed in appeal, the appellate court may, if it thinks fit, by order remand the case and may further direct what issue or issues shall be tried in the case so remanded, and shall send a copy of its judgment and order to the court from whose decree the appeal is preferred, which directions to readmit the suit under its original number in the register of civil suits and proceed to determine the suit and the evidence, if any, recorded during the original trial shall, subject to all just exceptions, be evidenced during the trial after remand. 23A. Remand in other cases where the court from whose decree an appeal is preferred has disposed of the case otherwise than on a preliminary point and the decree is reversed in appeal and retrial is considered necessary, the appellate court shall have the same power as it has under Rule 23, and Rule 25, where the appellate courts may frame issues and refer them for trial to court whose decree appeal from. Where the court from whose decree the appeal is preferred has omitted to frame or try any issue or to determine any question of fact which appears to the appellate court essential to right decision of the suit upon the merits, the appellate court may, if necessary, frame issue and refer the same for trial to the court from whose decree the appeal is preferred, and in such case shall direct such court to take additional evidence required, and such court shall proceed to try such issues and shall return the evidence to the appellate court together with its findings thereon and the reason thereof within such time as may be fixed by the appellate court or extended by its from time to time. Lordship. With that submission, I conclude my submission, Lordship, and interference of this honorable court may not be warranted, and this RFA is liable to be rejected, Lordship.
Yes.
My Lord, just some very few points. My Lord, regarding the first point, my Lord, my learned friend, day before yesterday, my Lord, on Friday, had taken your Lordship to page number 147, my Lord, of the paper book, which is regarding the judgment and order, my Lord. Lordship, specifically paragraph number 22.
Yes.
There, my learned friend had mentioned, my Lord, about a marriage between the appellant and one person by the name Rosama. My Lord, at paragraph number 22. And says that only two children were born in the wedlock between Thanginglova, and the two were born in the wedlock between she and some other person, my Lord, Rosam. But, my Lord, with this respect, I would like to mention and clarify that no evidence was led in this respect, my Lord. This is for the first time, my Lord, in the argument stage, this fact has been mentioned, and I'm not sure how they have come up with these facts, my Lord. So it is not backed by any evidence. It was not led by the plaintiffs in the lower court, my lord. That's the first point I want to mention. Basically, it has no legs to stand. So that's the first, my lord. And regarding the bridesmaid they had mentioned, my lord, at page 119. So my learned friend had mentioned that there was a bridesmaid, and at 118, my lord, the so-called bridesmaid at page 118 at paragraph number 3, she had mentioned about giving of bridesmaid and I am the bridesmaid of the marriage and so she had mentioned. And my lord, she had also mentioned at paragraph number 4 that bride price was paid and all of those things. But if your lordship will see the cross-examination at 119, my lord, she had stated, my lord, it is a fact that I do not know whether the bride price was paid or not. So this is directly contradicted by her previous statements. So these are 2 points, my lord. And regarding the third point,
Yes.
regarding the third point, my lord, issue number 1, my learned friend had dwelt in the issue number 1 for a significant period, my lord. With issue number 1, my lord, let me just point out one thing. When the learned trial court, my lord, was passing the order with respect to the issue number 1, the learned trial court had referred to, my lord, order 4, rule 1. The learned trial court had referred to order 4, rule 1. Now, order 4, rule 1, my lord, says like this: every suit shall be instituted by presenting a plaint in duplicate to the court or such officer as it appoints in this behalf. Every plaint shall comply with the rules contained in orders 6 and 7 so far as they are applicable. Now, the learned trial judge, my lord, had said order 4 has to be read with orders 6 and 7, which is correct. And this refers to institution of suits, my lord. Now, in our case, my lord, order 6 and order 6 talks about signing of pleadings. But, my lord, this order 4, order 4 deals with institution of suits. Now, in our case, my lord, the suit was not instituted by us. It was instituted by the opposite party, my lord, the other side, the respondent. It was instituted by the respondent, and in fact, the respondents themselves have not complied with this particular order, my lord. Order 6, rule 14, signing. They have not signed. She has not signed anywhere. It says pleadings to be signed, my lord. 14. Every pleading shall be signed by the party and his pleader. It's not used or, my lord. It's and his pleader. Every pleading shall be signed by the party and his pleader, my lord. In their pleadings, only the pleader had signed. I mean, in the first part, not in the verification. They were not referring to the verification for our case, my lord. Even in their case at page 1, there is no reason why we should refer to their verification if our verification is not being referred to, my lord. And in their pleadings also, only the counsel had signed, my lord. And they are the ones who instituted the suit.
Okay, one is order 6, rule 14,
Yes, my lord.
and the other one is order 4, rule 1.
Yes, because in the judgment, my lord, it says read with order 4, rule 1, read with order 6, rule 14.
So 4.1 basically talks about the institution of the suit,
Yes,
and they should comply with the orders 6 and 7.
yes. And Order 6 deals with pleadings.
6 pleadings to be signed.
Yes,
Additionally, apart from the pleader, the party has to sign.
correct.
That's what you say.
Yes, because it says and not or.
And what about order 7?
Order 7 is plaint.
Okay, before that, 14 is pleadings to be signed. Then
Yes.
15 is verification of pleadings.
Correct. And Order 7 is plaint.
Order 7 is plaint.
Yes.
Anything which is relevant for the present case in order 7?
Order 7, of course, my lord. If they are going to say we have not stuck to the rules, my lord, Order 7, Rule 1, my lord, how a plaint should be instituted, what has to be included in the plaint, all of those things have been mentioned. Page 1 of the paper book contains their plaint application, my lord, which was not amended till the end. It contains nothing of this, my lord. I mean, it contains some, but it does not contain the entirety of these things.
So basically, the defense is what? If they say that I have not complied, he himself has not complied with.
Correct. They cannot blow hot and cold. That's what I'm trying to say, my lord. They should not be allowed to blow hot and cold, my lord. We have not complied with one small thing.
What about that issue regarding curable defect?
Yes, my lord. The
Where is
Supreme-
that? You had relied upon some decision. What was that?
Yes, my lord. This is the first is the 1993 Guwahati law reports, my lord.
How many witnesses did you have?
We had 3 witnesses, and the plaintiff was witness number. The defendant was witness number 1. And she had mentioned everything exactly like how it was mentioned in the written statement cum counterclaim.
Then read on. 16.
16. It may also add here that Mr. Sharma has placed reliance on 2 decisions, namely Daya Bhai versus Bobaji Dayaji, so and so, my lord. In Daya Bhai Supra, Honorable Chief Justice Chakla of Bombay High Court, as his lordship then was held that if a plaint is not signed by a properly authorized person, prayer can be allowed for signing a plaint by the plaintiff even after limitation. In Bikaji Keshau Supra, the Apex Court, while considering Section 83(1) of the Representation of the People's Act 1951 vis-a-vis Order 6, Rule 15 CPC, held that even if there was absence of date in the verification of the election petition, it would be a good ground for dismissal of the application. Normally, the petitioner should be allowed to remove the lacuna by adding a supplementary verification. Though these 2 decisions are not directly on the point, I am only referring to these 2 decisions to show that provisions of Order 6, Rule 15 CPC are not mandatory. My lord, they are not mandatory, but are directory in nature. I therefore hold that Order 6, Rule 15 CPC is not mandatory and any defect can be cured at any stage. It can even be cured in this court, my lord. And my lord, even in the Supreme Court judgment which I had cited, also it says the same thing.
Okay, then what do you say about the issues being framed?
My lord, the issues being framed, let me say like this, my lord. There are 2 things. First is, my lord, my learned friend had alluded to the remanding of this case to the lower court. My my big reservation in this respect, my lord, is because this is a case pertaining to pension, and my own client, my lord, was always relying on her husband's maintenance her whole life. And not just the maintenance, now she is waiting for the pensions, my lord, to be solved. Now, if the case gets remanded, my lord, this is the reservation I have, my lord, it will drag on for much more longer, especially in a pension case, my lord. The Supreme Court has always been equivocal. My lord has always stated that pension cases should be disposed of as soon as possible. That's one problem I have with remanding the case. And the second is, my lord, if the case gets remanded, let's say, because this court also can ask the defendant, the defendant to cure the defect, just have to come and sign it if the defendant is willing to come and sign it. Now, the problem I have, my lord, is if it goes back to the trial court, what will the trial court do, my lord? It will do the same thing. Ask the defendant to sign the document, to sign the verification. There's nothing more it can do, my lord. The same thing will be served. So my humble prayer, and on top of that, my lord, the Guwahati High Court said that if the witness, if they have come as a witness in the witness box and has testified to everything, my lord, then there is no requirement for curing that defect also, because then that would amount to curing the defect. I mean, that's how I understand the Guwahati High Court judgment.
You had referred to a few of these documents,
Yes.
which in fact are in your favor, which has not been addressed by the learned trial court.
Yes.
And apparently, from the submission of Mr. Johnny, it appears that since that issue was decided against you
Yes.
regarding the counterclaim,
Yes.
so the question did not arise to refer to those documents.
No, but he referred to our arguments without referring to those documents, my lord.
Well, whether that will be permissible. When at one point he says that it is not, there's some defect in the plane, it's not been signed, so issue is against them. And later point of time, further observations made to whatever you have stated. Basically, what you have stated, no, you had filed additional affidavit also, additional document.
Yes.
That was Form 7.
Form 7.
Now, why I'm asking you that question is that, in fact, the issues were framed twice.
Correct.
Earlier, at one point of time, it was framed,
It was framed.
and immediately thereafter, the plaintiff was examined.
Correct. It went on. The trial went
And
on.
before the others could be examined, you filed your, what do you call,
No,
your counterclaim.
No, that's wrong, my lord. The sequential of what my learned friend had submitted is wrong. First was, my lord, they filed an application. Let me clarify again, my lord. They filed an application without impleading us. We were not impleaded in that application. Newspaper notice was issued. And that newspaper, based on that newspaper notification, my lord, airship certificate was issued to her with respect to the pensions and other things. When the airship certificates were issued, my lord, as soon as we found out, we came to this court, my lord. So we came to this court, and this court passed an order setting aside that airship certificate, as well as the order passed in that airship certificate application,
Remanded the matter back.
and remanded the matter back. And it was remanded at the stage of filing written statement cum counterclaim, my lord. So then we filed the written statement cum counterclaim, my lord. And then after filing the written statement cum counterclaim, issues were framed. And
Then
after
this impugn order was passed.
trial was held, long drawn trial, my lord. And after the trial, in fact, the trial went on, my lord, because order was passed during COVID 2021. So basically it went on for almost 2.5 years, my lord, Lunglei. And after this trial, order was passed, and just before this impugn judgment was passed, my lord. In fact, as far as I can understand, the issues framed, newly framed, were only reflected in the impugn judgment order, not in the order sheet. So that is the sequence of the case, my lord. It's not as if we filed our counterclaim after the first issues were framed. We filed our counterclaim much before that. And it was based on the entirety of the pleadings, my lord, that the court framed the issues. My lord, our counterclaim, if your lordship will look at the counterclaim.
See, the framing of issues, the first,
Yes.
at the first point of time was 27/6/2019.
27-6, my lord.
27/6/2019.
Yes.
Then the plaintiff himself examined herself
Yes,
on 17/7/2019,
correct.
just after the issuance of framing of the issues.
Yes,
Then the next witness number 2 was examined on 23/8/2019.
correct. Counterclaim was filed on 14 June 2019, my lord, to the best of my knowledge.
Counterclaim submitted on?
It was dated 14 June 2019, my lord. The date is 14 June 2019.
That was before the examination.
Yes, before the issues were framed. I think my learned friend was slightly confused with the written statement with some objection which was submitted by his client, my lord, at page number 17. But that is a different matter, my lord. 17, he submitted some misapplication, my lord. Now that was dated 18th day of July 2019. This was, even this was before, yes, my lord, just one, let me just see, my lord, if there's any extra issues. Yes. My lord, that's it.
Evidently, learned counsel for the appellant, and Mr. Johnny L. Tochong, learned counsel for the respondent. Stop parties have made their respective submissions. The hearing is concluded. Judgment reserved. These books actually, I think you can send me the books.
Item number 8.
My lord, this is a...
Yes, Miss Linda, anything?
Yes, I'm appearing for the respondent 1 to 4 in this case.
1 to 4.
Yes, my lord.
And you?
I'm appearing on behalf of respondent number 5.
5. Who's 5?
Van Roshili.
No, what is your relation? Who's 1 to 4? No, what are they? Who are they? These are private respondents.
Yes.
They're all private respondents,
We
my
are
lord.
all private.
Why so many private respondents here?
My lord,
Somehow they are related, my lord.
1 and
Respondent,
2 are brothers and sisters. 2 and 3 are father and son.
Okay. Okay. So this is a writ petition, is it?
yes, my lord.
Challenging?
Lok Adalat award, my lord.
Well, let us see where is the award.
English translation is in page number 3, my lord.
Page number
3.
3.
Yes, my lord. May I read it, my lord?
Before the Lok Adalat happened, what was the case?
My lord, initially on 5th January 2018, there was a money lend. The respondent number 5 borrowed money from...
No, was any case filed?
No, my lord.
No case filed.
No case. Application seems to have been filed before the village
This is
council
a
court.
sort of a pre-litigation.
Yes.
Even before filing any litigation, there was a Lok Adalat.
Yes, my lord.
Okay. Yes, please tell us, what is the story?
Shall I read out the Lok Adalat what, my lord, first?
No, you just briefly explain what is involved here.
My lord, on 5th January 2018, in annexure number 1, page number 13, my lord.
I mean the synopsis.
Yes.
Okay, you don't have to go to all this detail. Just tell me what is the story behind. Money was borrowed?
Money was borrowed by respondent number 5 from respondent number 4, my lord. No, sorry, respondent number 1, my lord. Money was borrowed by respondent number 5 from respondent number 1. And village council pass owned by the petitioner was put in mortgage, my lord.
Whom did you give the council pass? Village council pass?
Yes, village council pass, my lord.
Okay, whom did you give the village council pass?
I handed over to respondent number 5, and she gave it as mortgage to respondent number 1, my lord. For a money borrowed from respondent number 1 to respondent number 2, my lord. Though money was borrowed, but it was not directly borrowed by respondent number 5 from respondent number 1. It was borrowed to his sister, who is respondent number 2, my lord.
How much is borrowed?
50,000, my lord.
50?
Yes.
Respondent number 5 borrowed 50,000 from respondent number 1.
To respondent number 2, my lord. To respondent number 2, not directly from respondent number 1.
Okay. True respondent number 2.
Yes, my lord.
For a sum of rupees 50,000.
Yes, my lord.
By mortgaging your VC pass.
Yes, my lord.
And you handed over the VC pass to respondent number 5.
Yes, my lord.
Okay. And you don't know respondent number 2.
Respondent number 2.
You are not in contact with respondent number 2.
Yes, I'm not in
Your contact person is respondent number 5.
Yes.
Why did you give the VC pass to respondent number 5?
Because respondent number 5, actually, she was informing me that she will get back the money as per the agreement, my lord.
Where is the agreement? Let's see the agreement.
Initial agreement is in page number 30, my lord. The English translation
30.
is 31, my lord.
31.
31. Even if we see this annexure, my lord, it's very clear that the respondent number 5 borrowed money from respondent number 5 to his sister. May I read out the content, my lord?
What is the name of the appellant? Lal Sangzwali.
Lal Sangzwali.
And the name of the respondent number 5?
Van Roshili, my lord.
Huh?
Van Roshili. In page number 31, her name appears in serial number 6, my lord.
But who is Lal Rohlua?
Lal Rohlua is the person who owned the money initially, my lord. The respondent number 5 borrowed the money from respondent number 1.
Lal Rohlua is respondent number 1?
Yes.
Okay.
May I read out the content, my lord, page number 31.
Yes.
I, Lal Rohlua, lent money 50,000 to Srimati Van Rohlili on 5th January 2018 by mortgaging this VC pass to be repaid back on April 5th, 2018. In case it is not settled within this period, they shall not have any say in respect of this VC pass. My lord, if we see this page number 31, kindly see the serial number, my lord. In serial number 1, the respondent number 2 name appears. And again, in between 1 and 2, respondent number 1 and respondent number 5 name appears. It seems like it's written later, my lord. And if I may take my lord to page number 30.
You are referring to the witness?
Yes,
Witnesses.
my lord. Witness. Name of the witness written in the...
Who is Lal Zaumi?
Zaumi is the respondent number 2, my lord. Sister of respondent number 1.
Respondent number 2. Then Lal Rohlua is the
The
respondent number 1.
Yes.
Then Lal Shetpuya.
Lal Shetpuya, that... not written... not...
It's not a party.
Yes, not the party, my lord.
Then Lal Sangzoli.
Is the petitioner, my lord. And Deborah Lerindigi is also not the party in this case, my lord.
And Van Rohlili?
Is the respondent number 5, my lord.
Right, 5. What are you just saying, that it is not serially made? What do you
Yes,
mean?
I say what I'm submitting is, my lord, respondent number 1 and 5 name appears in between 1 and 2 and 3 and 4, which seems that their name are written on a later date, my lord, not on the date of agreement, my lord.
Now, how do we know that?
The serial number, my lord, page in serial number 1 it's Lel Zaomi, and 2 it's Lel Hitbui. In between 1 and 2, serial number 5 appears, my lord. Though the date is not written,
Okay,
my lord.
it's not in serial wise.
Yes, yes.
It comes in between. That's what you want to
Yes,
say.
yes, my lord.
So now here, this is an agreement between the respondent number 1 and respondent number 5.
Yes,
And the VC pass belongs to you.
yes, my lord.
Respondent number 1 says that I have lent rupees 50,000 to respondent number 5 on
5th
on
January
receiving the mortgage, VC pass,
Yes.
mortgage by respondent number 5.
Yes, my lord.
And the VC pass belongs to you.
Yes, my lord.
Then thereafter what happened?
Thereafter, on 9th January 2018, my lord. 9 January 2008,
This is the date of agreement is 17/5 or what?
somewhere it appears 9 January, sometimes it appears, my lord. I think the date is 9 January. There on top, the date is different, my lord, 17 May 2008.
So,
I think the correct date must be 9 January 2018, my lord.
what is 17 May 2008? And why signature is of 2018? Difference of 10 years.
Yes, my lord. I
What
don't know
does it
how
mean?
it appears, my lord, that
SVC means what? SVC number 107?
Sesong Village Council.
107, I don't know.
So, is there any village council president here or member on the signatory?
No, no, my lord.
Then why this VC thing is there?
Can't explain, my lord.
Agreement dated 9/1/18. So after that,
And
any
again-
time limit? Okay, 5th April.
Yes.
5th April 2018. Then,
And my lord, if I may take you to page number 34, my lord. Page number 34, my lord.
yes.
May I read out from line number 4, my lord. Sri Lal Rohlua, as asked by the chairman, explained that he approached Village Council Court, Sesong, because Srimati Van Rohili did not repay his money within the time frame as agreed. Srimati Lal Sangzoli submitted that she is not ready to surrender oblique laws her Village Council passed mortgaged by Srimati Van Rohili to Sri Lal Rohlua, and further submitted that out of sympathy to Srimati Van Rohili, she agreed to lend her Village Council pass as mortgaged property by borrowing 50,000 from Sri Lal Rohlua. Srimati Lal Sangzoli wished that Van Rohili repay the money borrowed by her to Sri Lal Rohlua. Srimati Van Rohili affirms that she borrowed money from Lal Rohlua as she is in dire need of money. She plans to repay as and when compensation is received. However, since money received from compensation is insufficient, she could repay the money. As request letter received from Sri Lal Rohlua, next page, my lord, Lower Kanan, to make arrangement of legal settlement with Srimati Van Rohili. As she failed to repay 50,000, the following is the arrangement made. Here, the VC make arrangement. I, Van Rohili, a daughter of Bontualate, Viva Conizol, undertakes that I shall repay the money borrowed by me, 50,000, latest by 1st June. Through this letter, my lord, the date is extended again, 1st June 2019, along with interest, that is 5,000, totaling 55,000. Srimati Lal Sangzoli also agreed to give her house site at CTI in case Srimati Van Rohili fails to repay.
Who is Van Lal Sangzoli?
The petitioner, my lord, the owner of the house pass.
Petitioner is the owner of the VC pass.
Yes, yes, VC pass, sorry.
So, what does it mean then? Srimati Van Lal Sangzoli also agreed to give her house site at CTI. To whom?
It seems like to the this respondent number 1.
To the respondent number 1.
Yes, my lord.
Okay.
But in that letter, in that document, my lord, the village council president, though his name appears, but his signature is not affixed in the document, my lord. Seems like it's an internal, in page number 35, my lord.
Okay.
The original is in page number 37, my lord.
Okay.
The vernacular, page number 37.
Is this what you're challenging?
No, no, what we're challenging is the Lok Adalat award, my lord.
Where's the Lok Adalat award? After this, what happens?
Yes, after that, my lord, there's, may take my lord to page number 38 again, my lord. 38 is the English translation again. That since Srimati Van Rohili could not repay back 50,000 to Sri Lal Rohila within 5th January 2018, as was promised by Lal Rohila, filed an application before Sesong Village Council Court. That on this first day of April 2019 at 11 a.m. at the 118th sitting of the Sesong Village Council, sitting held at the Village Council House, unanimously made undertaking in respect of the money borrowed by Srimati Van Rohili from Sri Lal Rohila Zadeng as under. I, Van Rohili, daughter of Bontua Vai Vakonaj, undertakes that I shall pay an amount of 55,000 along with 5,000 to Sri Lal Rohila by 1st June 2019. That's the... Sorry, my lord. My lord, may I take you to page number 44, my
What
lord.
is this which you just read?
What I just read is the extension of the time limit, my lord.
How do you say it's extension?
Here in para number 2, my lord, page number 37. Second para, my lord. I, Van Rohili, daughter of Bontua, Vai Vakonazol, undertake that I shall pay an amount of 55, that is 50,000, along with 5,000 to Sri Lal Rohila, latest by 1st June 2019, my lord.
But the page 38, second line,
Yes.
the date is 5/1/18. How can it be 5/1/18? The first money lending happened on 9/1/2018. Then the Village Council Court has made an order on 1/4/2019 to repay the money latest by 1st of June. Then you take me to page 38, which again now says that failed to return the money by 5th January 2018. There's something wrong here.
Here, even in the original, my lord, some seems like date is, they made the wrong date, my lord. My lord, in page number 31, the English translation of page number 30, my lord, Annexure 1. Here it says that time is given till 5th April 2018. Page number 31, my lord, the English translation of Annexure 1.
Page 30?
31, my lord. 30 is the vernacular, my lord.
Yes, so
31, in here it says that I, Lal Rohila, lent money 50,000 to Van Rohili on 5th January 2018 by mortgaging this VC pass to be repaid back on April 5th, 2018.
Okay.
Here the date is till 5th April 2018.
Okay.
And from there, through this letter, my lord, Annexure 3, my lord, they extended the date till 1st June 2019.
not Annexure 3. You come to Annexure 2 first. After this, Annexure 1 comes Annexure 2, I think.
Okay, my lord. Shall I read out the English translation, my lord, which is in page number 34, my lord?
Translation is not correct, I think. See, the first agreement is Annexure 1. 1A is the translation. Okay?
Yes, my lord.
And the agreement is dated, signed on 9/1/2018. Date of repayment is 5/4/2018.
Yes.
But the village council has sat together on 1st April 2019,
Yes, my lord.
even before the date of repayment has arrived. Date of
No, my
repayment
lord.
was 5th of April 2018.
2018, my
Okay,
lord.
this is 19,
Yes,
okay.
yes.
This is 2019, okay.
Yes, my lord. The Annexure 2 is 1st April 2019, my lord.
Okay. Then Annexure 3, This also talks about 1st April 2019.
Exactly, same date, my lord. If I may take, my lord, to page number 44, my lord. On 22nd June 2019, my lord, there was a village council sitting, 124th sitting, and the
Page
relevant,
number 44.
yes, the relevant part is in page number 45, my lord. May I read out, my lord?
Yes.
Agenda number 10, my lord. As passed by VC sitting number 118, that if Srimati Vandrahuli, daughter of Bonto, fails to repay 50,000 along with interest, that is 5,000, to Sri Lal Rohlua by 1st June 2019, mortgage property house site owned by Lal Sangzoli shall be mutated in the name of Sri Lal Rohlua Zadeng, Lower Kanan Aizol. That till to date, 22nd June 2019, the borrowed money has not yet been repaid. After sincere discussion regarding the house pass which is in the name of Srimati Sangzoli presently, as requested and asked by Sri Lal Rohlua, it has been decided by the meeting that the house pass of Srimati Sangzoli shall be mutated in the name of Sri Lal Rohlua, Lower Kanan. The VC sitting was held on this date, my lord, and on the same date, this VC pass was mutated in the name of respondent number 1.
So this VC sitting happened, it happened after which date? First of all, it was the agreement.
Yes.
Then secondly, the VC sitting was
1st April 2018, my lord.
1st April.
Yes, my lord. 2019, sorry.
1st April 2019.
19.
Then comes
22nd June 2019, my lord.
22nd June.
2019.
Where is that page?
Page number 40, my lord. Annex 4.
What about 36?
'36 is the same date, my lord, 1st April 2019. It seems like on 1st April 2019, they make two documents, my lord. One is the VC sitting minute, and the other seems to be an undertaking, my lord.
Next sitting is 22nd June.
Yes, my lord, 22nd June 2019.
Then
on the same date, my lord, the VC pass was mutated in the name of the respondent number 1. That is 22nd June 2019, my lord. It's in page number 46, which is in the next 5, my lord.
page number?
Page number 46, my lord. The next 5.
Where's the original VC pass?
That, my lord, I cannot procure, my lord. Though this also actually it's just a picture clicked by the petitioner, it seems, my lord. I don't see the original VC pass, my lord. I don't get the original VC pass, my lord.
Does it have a number or something? Any number?
I guess so, my lord. Even when we filed the second or third Lok Adalat application, we demand a photocopy of that thing, but we were not given, my lord.
This page 31 agreement is there. 31. Regarding lending of money.
No, I mean,
I understand.
yes, yes.
There's
After
no
the
mention. There
Yes.
is no mention about the VC pass number or something like that.
Yes, my lord.
It just says VC pass.
Yes.
So how do we know which VC pass, what VC pass? Now you come to page 46 and say that this is the new VC pass given to the respondent number 1. Correct?
Yes, my lord. It's mutated in the name of respondent number 1 from the petitioner, my lord.
Where does it show here? It's from the respondent number 1. Yeah, it's from the petitioner.
My Lord, why I'm saying so? Because reading the Lok Adalat award, it says so, my Lord. If I may read Lok Adalat award, my Lord. The English translation is in page number 3, my Lord. Till today, my Lord, I don't see the original VC pass. Somehow it's quite difficult. May I read
So
out
this VC pass was given on which date?
to the petitioner, my Lord?
No, to the respondent number 1.
Respondent number 1, my Lord, 22nd June 2019, my Lord, which is in Annexure 5, page 46,
22nd June.
2019.
So after this, what happened?
After this, actually the petitioner, respondent number 5 filed Lok Adalat application. I'm not the one who filed the Lok Adalat application. My Lord, application is in page number 49.
Respondent number 5.
Yes, my Lord. She being the person who mortgaged the property to respondent number 1, my Lord. I'm not the one who filed the Lok Adalat application, my Lord.
So you were not aggrieved by your land being given to somebody else?
It seems like the petitioner consented to the mortgage of that property, my Lord. Though she was not ready to surrender that thing to the respondent number 1, my Lord.
The VC pass was in your name.
Yes.
You gave it to the respondent number
5.
5.
Yes.
Who borrowed money from respondent number 1.
Yes, my Lord.
Through respondent number 2.
Yes.
So after this VC pass was transferred in the name of respondent number 1, you did not do anything?
No, my Lord. We never know that it was transferred, my Lord. Only when I filed the writ petition, they were aware, my Lord.
Only when you filed writ petition?
Yes. That also only orally, my Lord. This, the photocopy of the VC pass, which is in page number 46, somehow it's quite difficult, my Lord. The application filed by respondent number 5 is in page number...
You are the writ petitioner.
Yes, my Lord.
You know what has happened. That's why you filed this writ petition. How do you say that you didn't know? If you didn't know, how did you file this writ petition?
Why I'm saying so? Because we never see the original transfer of the mutation of the VC pass, my Lord. Just through orally, my Lord.
But this is what you have annexed. This is the VC pass given to the respondent number 1. So anyway, let's come to the Lok Adalat. I don't know.
Application is in page number 49, my Lord. It's in vernacular. Shall I read out the English translation?
Page?
49 is the vernacular application filed by respondent number 5, my Lord. Lok Adalat application. English translation is in page number 51, my Lord.
You read the Mizo vernacular one. Come to page 1. This is the one, isn't it?
Yes, 49, my Lord. 49 is the application filed by respondent number 5, my Lord.
No, I'm talking about the award.
Okay.
There was an application also.
Prior to Lok Adalat award, my Lord, there was application filed by respondent number 5, my Lord.
Where is that? Show me.
It's in page number 49, my Lord.
49.
It's the Mizo version, my Lord. Shall I read out, my Lord?
Who has filed this?
Respondent number 5, my Lord.
Okay, just a minute. There is no date, but it's a date of receipt is 25/7.
Yes, my Lord. Shall I read out the application? Kum sang ni somporiat kan har satema wangin pilal sang zole teram VC pass chu paisapuk natur atan man kadila anni po chuan kadin munte thiamin milo man tira ti chuan pulal ro hlo hna afar nu kal tlangin cheng singa kapuk saka chu poisa ka dona tang chuan cheng sangre chu pilal sang zole hna lo manatan ka pevea tin cheng sanga chu afar nu lel zo min hna ka peve boka aman aphu tangin chome zorna turatan bultan natur ani Angin chanem ngai de win chokme ka zuar chovea mai thai kania ka fate panhile ka uk en kol tel bok angai wangin ka poisa puk po chu alomin ka rul thei meulova alom lowa pe ka tumlain andu bok silova pila sang zolite laka po ka in tharung le ani masela ni ro chon min thatiam zela din mun har sa takara ka online ka paten anram compensation andon ve atagin cheng sing tu min pia poisa ka don ve awang chuan cheng sing ni chu first installment a pe ka tuma lel ro hlu far nu chuan a interest chau pe angin min chu sakatum zela ke ni chuan a principal atanga min kat sak tura kan be se awangin a far nu min ti dan chu kan du big talova chu tianga ni ta ka chuan lel ro hlu te hian vc court a min king ta vc te chuan ni khat jun sang ni som pakwa ralma in rule taturin le karul theilawani chuan pilal sang zuli hian apas chu pek mai rem ti ve ta boka covid 3 te lo lenta ka chuan kan har satna te azual chawa han rulna mai turpo tho chu har sa lo har sa pulal ro hi thatakin kan khila ani po hian min tha thiam zela ahlom chawa poisa don andu awangin poisa kain khol chho ve meka din mun har sa taka kom line ni somni pali july sangni le somni pani sunday khan lel ro hlua hian te hian put thang dai lovate ne na an lo thal tamaya covid borok te aje omta ka wangin poisa po kalain khol ve kain khol ve thei to a rul tla ka tummek laya hetia an lo thal tamai hi ka hletiam lo hlea khonga ya heram an lo thal to hi pilal sang zulite kuta om let le thei ngei nana ma min lak pui turin ka ngen chia tin ka poisa puk sak po rul thei turin ka din mun po aje om ve to baga ka poisa min man pui tu te hian min rul let ve turin ka besi bokani rin tlak wan rofi who is the respondent number 5 my lord.
Come back to page 49.
Yes my lord.
The fourth last line, read that. VC te chuan jun ni khat sang ni som pakwaral ma in rul tlaturin le karul theilawani chuan pila sang zolian and pass to pek mai rem ti ve ta boka Stop there.
Yes.
So the Sanzoli also was agreeable to give the pass.
Somehow she was compelled, my lord.
Huh?
Somehow she was compelled.
No, if she doesn't get the money back also, she doesn't mind parting with the pass. Is that the story?
It's written, but somehow, 1 minute, my lord. My lord, if I may take you to page number 32, my lord, which is in Mizo version, my lord. Somehow she was compelled, my lord.
32.
32, my lord.
No, what is this?
1st April 2019, my lord. Rorel Pakhatna, Chairman, shall I read out, my lord? Chairman, in Pulel Rohlo Upper Kanan, Isol Pusapuk, Tier 2 Jus Soitura, Somin Pulel Rohlo Chon, to Mangle, Huntiam, Chunga, Pusapuk, to Pivan Rohili, Filin, Poisa Apek, Loa Vanga, Village Council Court Sesong, Aron Klen, to Tesoin, Chairman in Inhun Pass, and Dakam. Nani tu pila sang zoli somin pila sang zoli chona poisa puki puk tu kanilawa ka khongai awangin ka in hun pass vis pivan ro thili hi a poisa cheng singa puk nan ka ho tir mai ania ke chuan ka in hun chan ka phallawa here somehow in some document it says that she was not ready, my lord. And on 13 August 2022, my lord, the Impian Lok Adalat was passed, my lord. And aggrieved by the Impian Lok Adalat, application was filed by the daughter and husband of the petitioner, my lord, which is in page number 56, my lord. Here also, date of application was not mentioned, but the date of receipt is 18/8/2022, my lord.
Just a minute. Before that, page 49, this is an application filed by the respondent number 5.
Yes.
The one who borrowed that VC pass from the petitioner.
Yes, my lord.
Then after that, what happened?
After that, Lok Adalat award, my lord, which in page number 1.
After this, straight away Lok Adalat award.
Yes. Page number 1 is the Lok Adalat award, my lord, vernacular version, my lord. Shall I read out, my lord?
Just a minute. Then who are the parties here? Opposite party?
Opposite party is the
The one
respondent,
who-
number 1, respondent number 1, 2, and the petitioner and respondent.
Yes. Please read the vernacular one.
Yes, my lord. Voin ni som pathum August ang ni som ni panhihian van rohili of vivacon petitioner le opposition party lel rohlua lel zaomi lel sang zoli le thangdai lovate kim takinan lokala pulal rohlua son of Rankima Kanan lower inmun number 124 dated 22nd June 2019 tun ma pilal sang zoli wife of 8 sang huaka pinga thin chu pusi lel tanpuya son of pu thangdai lova se song 3 minga thak remti ania in mun le achunga zong zong aneyang hemichin felnan hian pulal rohlua lower kanan le pu si lel tanpuya te ten pilal sang zoli tanpui nan cheng sing khat ve an peanga August som sang ni pani chungin an peang. Next page, man. Hey bag ahian pila sang zoli fanu ar zonun sang chu ain lua laya hian December sang ni somni patum tlenga thleng in manga in lo man hi August sang somni pani thleng ala bok ang thlatara tang chuan pusila tanpuya pusila tanpuyan ala toang pivan ro rili hi in pila sang zoli teram atiral sakawangin pila sang zoli hian cheng noi li singa phuta voin ni som patum August sang ni somni pani hian cheng singa penghala alabak cheng noi li chu thatin in a rulang. In fact, we never demanded any money from the respondent number 5, my lord. That 50,000 was carried by the petition by the respondent number 5 on the date of Lok Adalat, who went to the Lok Adalat along with the petitioner, my lord. If I really demanded 50,000 from the respondent number 5, I can get it on our way to Lok Adalat, my lord. Though we never demanded 4,50,000. And even this 4 lakhs also, my lord, it just says alabak cheng noi li chu thatin in a rulang. It's not clear, my lord.
Okay, so have you received the money?
Which money? From 4 lakhs?
50,000?
50,000, I received it in the Lok Adalat, my lord.
So if you said you did not avast the money, why did you receive it?
That's main point of argument, my lord. These conciliators, somehow they conducted the Lok Adalat almost like a judicial proceeding, and I was like directed to receive that money, my lord.
How can you be directed to receive money by force if you don't want to receive the money?
Not forcefully, but I was informed that I don't have any other option. Since that VC pass was already mutated in the name of respondent number 1 on the date of Lok Adalat award, my lord. I, as advised by the conciliator, since I don't have any other option, so I was like directed to receive that money from the respondent number 5, my lord.
Okay, supposing this Lok Adalat order was passed under duress or without your actual consent, set aside, then what happens?
I have to challenge that mutation, no, my lord. Somehow this Lok Adalat award bars me to challenge that mutation, my lord.
Mutation in the name of?
Respondent number 1.
Who is that?
Lel Rohlu Azadeng, my lord.
No, he has sold it to Silal Chanpuya, isn't it?
That it's written, but I think the VC pass is still in the name of Lel Rohlu Azadeng, my lord. My lord, if I may submit this picture to make it clear, my lord.
No, just a minute.
2 houses are there in the VC pass, that's what I'm saying. 2 houses, 2 Assam type building are there, no, my lord, here. I visited the spot also, my lord.
No, not required. We don't require that all those picturesque. See, what we are concerned here is whether the provision of this, what you call, the Lok Adalat award has been passed in accordance with law or not. Thing is that, now where is your submission regarding this Lok Adalat award being without your consent and all that, without you being agreeable?
My ground is in page number 22, my lord. Ground is in page number 22 of my...
22,
22, my lord.
24.
22, my lord. It's in para number 17, my lord.
Yes.
Shall I read out, my lord? From point number 1, my lord. For that, the Lok Adalat conducted on 13/8/2022 and comprising of Sri Thomas Lelramoya, judicial officer, Dr. Lelrin Tluang, a social worker, and Professor Zoukai Tluangi, erred in law and in fact in passing the impugned Lok Adalat award dated 13/8/2022 in Lok Adalat pre-case number 357 of 2022, and as such the same is liable to be set aside and quashed. Point number 2, my lord. For that, the impugned Lok Adalat award dated 13/8/2022 was passed without the free consent of all the parties, more particularly the petitioner. In fact, the petitioner was compelled to sign the impugned Lok Adalat award under the influence and coercion. In fact, the petitioner had been informed by the conciliator sitting therein that she has no other option but to sign the impugned Lok Adalat award. Point number 3. For that, the impugned Lok Adalat award dated 13/8/2022 is liable to be set aside inasmuch as it had been conducted in a very biased manner and more like a judicial proceeding. For that, in the case of State of Punjab versus Punjab and another versus Jolar Singh and others, 2008-2 SEC 660, the three-judge bench of the Honorable Supreme Court at paragraph number 8 has held that Lok Adalat have no adjudicatory or judicial functions. No Lok Adalat has the power to hear parties to adjudicate cases as a court does. In their conciliatory role, the Lok Adalats are guided by the principles of justice, equity, and fair play. Point number 4. For that, the impugned Lok Adalat award dated 13/8/2022 had been passed without appreciating the correct facts and without affording fair opportunity to the petitioner. That the impugned Lok Adalat award wrongly recorded that the petitioner demanded 4,50,000 from respondent number 5. That the petitioner never demanded a single rupee from respondent number 5 at the time of Lok Adalat sitting held on 13/8/2022. The conciliator sitting therein have made arrangement and accordingly directed respondent number 5 to make payment amounting to 50,000 to the petitioner, which in fact has been carried by the respondent number 5 at the time of Lok Adalat sitting held on 13/8/2022 to be handed over to the respondent number 1. Hence, an amount of 50,000 has been handed over to the petitioner by respondent number 5 as per direction given by the conciliator sitting therein. The impugned Lok Adalat award intentionally then recorded as if the petitioner demanded 4,50,000 from the respondent number 5. Point number 5. That the impugned Lok Adalat award dated 13/8/22 has been recorded and passed favoring only the respondent number 1 and respondent number 4. The petitioner was not given a chance to submit her point of view at the time of Lok Adalat sitting held on 13/8/22. Instead, she was informed that she has no remedy to get back her village council pass, house pass, as the same has already been sold by respondent number 1 to respondent number 4. In fact, the petitioner has been compelled and forced upon to sign the impugned Lok Adalat award without her consent and free will. Point number 6. For that, the impugned Lok Adalat award dated 13/8/22 has been recorded and passed totally opposite to the prayer made in the application filed by the respondent number 5. Point number 7. For that, the impugned Lok Adalat award dated 13/8/22 simply mentioned that 4 lakh shall be paid by the respondent number 5 to the petitioner monthly, but failed to record the amount to be paid monthly and no time period to complete the payment has been recorded. This is because the impugned Lok Adalat award has not been passed on a compromise or settlement between the parties. In fact, the conciliator sitting therein in a very mechanical manner has passed the impugned Lok Adalat award after hearing the rights and submissions made by the respondent number 1 and respondent number 4 only. Point number 8, my lord. For that, the impugned Lok Adalat award dated 13/8/22 was passed in the absence of one of the necessary party, namely Srimati R. Zaununsangi, who is the daughter of the petitioner, who has been in possession of one of the buildings within the village council house pass located at CTI Sesong owned by the petitioner. The impugned Lok Adalat award has been passed without giving someone or opportunity to Srimati R. Zaununsangi. Point number 9. For that, the impugned Lok Adalat award dated 13/8/22 is simply an affirmation of the decisions made by the Sesong Village Council sitting number 124 held on 22nd June 2019 in respect of Village Council pass owned by the petitioner. Point number 10. For that, the impugned Lok Adalat award is liable to be set aside and quashed inasmuch as it was not based on a compromise or settlement arrived at by the parties. In fact, it was not according to the intent of and purpose of the Lok Adalat. My lord, here, additionally, if I may submit, my lord, that 50,000 frankly speaking, my lord, the petitioner has another case before this Honorable High Court. Though initially it was before the district court, my lord, MSCT case. It was handled by Sri Jonia, the person who was just...
So?
The respondent number 5 and petitioner went before him, and they were advised that since the borrowed money is only 50,000, so he directed that just carry that thing because Lok Adalat cannot award interest. So the respondent number 5 and respondent number 1 together went to the Lok Adalat, my lord. The respondent number 5, the petitioner never demanded money from the respondent number 5, my lord. That respondent number 5 also, actually, it's not like, it seems like she collected that 50,000 from her relatives, it seems. They went together, and that in the Lok Adalat reward, it was written as if I demanded 4,50,000 from the respondent number 5, my lord.
But that's what you already said.
Yes.
That you never demanded the money.
Yes.
So what is that other case you're referring to? Any other case pending on this connection?
No, it's not. Why I'm saying so, because Sri Joni take up that case. That's what I'm saying, my lord.
Take up the case
MSCT
where?
appeal.
Where?
Before
Which
this
case?
Honorable High Court.
Which case?
Joni represented Lal Sangswali, who is the petitioner here in, before this Honorable High Court.
So what happened to that case?
It's still pending, my lord.
Is it related to this case?
No, why I'm saying so, because since Joni and the petitioner are known to each other, that's what I'm saying, my lord. She consulted Joni, who used to sit as a conciliator in the Lok Adalat. So on his advice, they carried that 50,000 before that Lok Adalat held on 13/8/2022 to be handed over to the respondent number 1, thinking that they can get back the village council pass.
No, what is that other case which you say that is pending?
It's MSCT appeal, my lord.
Huh? MSCT appeal?
Yes, yes. It's different case. Why I'm saying so, because the petitioner and Sri Joni, they are known to each other. That's what I'm just trying to say, my lord.
So what is wrong in that? They may know each other.
Why I'm mentioning that, my lord, as I submit, the respondent number 5 and the petitioner approached Sri Joni, taking his advice. And since the borrowed initial money borrowed from the respondent number 1 is only 50,000, he advised them that Lok Adalat cannot pass interest. So just carry that 50,000, and it seems like he advised to take that 50,000 to the Lok Adalat.
And so they gave it to you, you accepted it.
No. As I say, I never demanded 4,50,000, my lord.
You never demanded, but you accepted the money, isn't it?
Yes.
So?
My lord.
For whatever reason they brought the money was given to you and saying that you have asked for 4.5 lakhs. So said, okay, take 5 lakhs, 550,000 now, and remaining money will be paid to you later on.
As I submit, my lord, since I am informed that I don't have any other option, so I'm compelled to take the 50,000.
You may say so many things after passing of the award, but what have you said before the award was passed?
Meaning the sitting?
Yes. At one sitting, everything was decided. This Lok Adalat sitting, how many times it was held?
The main hearing is only on the 13th, my lord.
Okay. Before this hearing, had you appeared before the Lok Adalat before? At any point of time?
I think the petitioner appeared, my lord.
That's what I'm saying. What have you stated before the Lok Adalat? What was your case?
Our case is only just to take that VC pass from the respondent number 1, my lord.
No, that's why. Have you submitted anything in writing?
No, not in
before the Lok Adalat.
writing. Not in writing.
How many sittings were there?
Total.
Everything happened verbally, orally.
Yes, it's orally, my lord. No compromise is written no such written compromise is there in the Lok Adalat, my lord, except the Lok Adalat award. And my lord,
page 49, the respondent number filed an application before the Lok Adalat saying this is the problem which I am having. Please solve this issue. Thereafter, you were summoned. You are serial number 3, Lal Sangswali, isn't it?
Yes, my lord.
You were summoned thereafter? Were you not summoned?
I was summoned, my lord, and even
when?
On 25th July 2022, my lord, according to the court order, my lord.
25th July?
Yes, it's in page number 54, my lord, of the Lok Adalat order.
Yes. What is recorded there?
Here, on 25th July 2022, my lord, received an application from Van Rohili against Lel Rohlua, Lel Zomi, Lel Sang Zoli, and Thang Dailawa in connection with civil suit. Issue summon to the parties. Here, summon was issued.
Then?
And it seems the next sitting is on the only the date of Lok Adalat award, my lord, 13/8/22. Though in between 11/8 to 22 is there, but here it says only return copy of summon. It seems like the award was passed on the same day, my lord.
After lengthy deliberation of the matter, the parties could have arrived at settlement. In terms of settlement, the terms of settlement are as per award from which award form, which is placed
on record.
Yes. So this is the award form.
Yes. My lord, even a reading from the submission of the counter affidavit, my lord, of the respondent number 1 to 4. Somehow I can find out that in serial number 11.2, my lord. 11.2, the last sentence, my lord.
Yes.
Here it says that presently owned, in the fourth line, my lord, fourth last line, my lord, presently owned by the respondent number 1, which was lawfully acquired by him from the respondent number 5, be mutated in the name of respondent number 3. In bracket, it says that the respondent number 3 bought the said land on 22nd July 2022.
What does it mean?
Why I'm saying so, my lord, even the Lok Adalat application, according to the receipt, is 25th July 2022. Even before filing the Lok Adalat application, my lord, it was already bought by respondent number 3 from respondent number 1, my lord. Said plot. Though sale deed has not been filed by the opposite party, my client informed me that the said VC pass had been sold by respondent number 1 to respondent number 3 for an amount of 3 lakhs, my lord. That 4.5 lakhs, my lord, as I submit, I never demanded from the respondent number 1. And why the conciliators calculate comes to 4.5, it's because that land has already been sold by respondent number 1 to respondent number 3.
Respondent number 3 is Thang Dailawa, is it?
Yes, my lord.
But there was another name also, I think.
Thang Dailawa is the father and respondent number 4 is the son, my lord. 3 and 4 are father and son, my lord.
So basically, at this stage, what is required to be considered by this court is whether the Lok Adalat award has been passed in accordance, in conformity with the provision, or whether it was passed under duress and without any agreement made by the petitioner. And what do you have to say on that? Any authority?
Supreme Court.
On what basis court can interfere in such kind of award? What is that?
My lord, it's State of Punjab and another versus Jalor Singh and others. It's 2008 2 SCC 660, my lord.
Is it the one which you had referred in your grounds?
Yes, yes.
The Lok Adalat cannot be adjudicated.
Yes, my lord.
Cannot adjudicate as
Yes, my lord. The relevant portion is in page number, from para number 8, which is in page number 665, my lord. Some of this Lok Adalat, it's conducted almost like a judicial proceeding. That's my main ground, my lord.
How is that conducted as a judicial proceeding? You only said that first day what notice was issued, second day someone duly served, third day it was decided. Where was the proceeding? There was no proceeding. You say that it's conducted like a judicial
No, I
proceeding.
mean the hearing date, my lord. Sorry.
But where does it reflect in the hearing that these are the proceedings conducted? These are basically the agreement reached by the parties. This has happened, as per agreement, this much will be given. That much will be given. And today you say that this was not what I agreed upon. And
Basically, the Lok Adalat award was passed almost from the submission made by the respondent number 1 and respondent number 3 to 4, my lord, 3 and 4.
you have also given your signature.
Though my signature is there, my lord, if we see the Lok Adalat award, somehow it's contrary also, my lord. From in first 3 lines, my lord, it says that Voinit Sombatum, because shall I read that, my lord? Page number. Voinit Sombatum, Tharit Sami Somni Panihian, Van Rotili, of Vivacon, petition of the opposition party, Lel Rolu, Lel Zomi, Le Sang Zoli, Le Tang Dai Lovate, Kim Takinan Lokala. And again, here in the signature part, my lord, in point number 4, in the second page, my lord, signature, Thang Dai Lava, represented by Silal Tanpui again. Here in the first page, it says that they are all present, and again, in the second part, they say it's represented by Silal Tanpuya.
Silal Tanpui is the son.
Yes.
Then, what else?
My lord, on record, I cannot submit any document because as I just submit, my lord.
See, a simple question is, if you don't agree with what has been written here, why did you sign? This is written in vernacular. You very well understood what is written here.
Sometimes, my lord, parties appearing before the law, they are not aware. And plus, like my client, if she is informed that she has no other remedy, somehow she don't have any other option but just to sign the Lok Adalat award, my lord. Even recently, another Lok Adalat cases, some Lok Adalat award are passed almost like a court orders, my lord.
Some others are some other things. We are concerned with this case. Now, thing is that if the Lok Adalat award records your agreement and you put your signature on it, can you later on come and say that, no, it was not my agreement and I didn't know what happened? How do we believe you?
Since it's conducted in Mizo, my lord, it's quite difficult to answer that question, my lord. But
You are not Mizo?
No, I'm saying since the Lok Adalat is proceeding is conducted in Mizo, like.
That's why it's easy for them to understand. Local people are there. It's conducted in the local language.
But my lord, some clients actually they think that Lok Adalat is almost like a court. So that's since if they are informed that they don't have any other remedy, somehow they don't have any other option but just to sign the Lok Adalat award. And plus, since sometimes they are not aware of the consequence of signing the Lok Adalat award also, my lord. As in my case, my lord. Even reading the Lok Adalat award, my lord, here, as I submit in, my lord, just one minute.
See, the thing is that you never came before the Lok Adalat. It was somebody else who came before the Lok Adalat. The person you gave the VC pass to. So, perhaps you were not aggrieved by the selling of your land to somebody else.
Since I'm the party in the Lok Adalat, my lord, I don't submit separate application, my lord. Because the respondent number 5 submitted this application to get back my VC pass, my lord. This award, I mean the Lok Adalat application, though has been filed by respondent number 5, but I'm the party in the Lok Adalat, my lord.
You're a party, no doubt. Somebody else has submitted on your behalf. Why didn't you yourself submit? That I lend this money to so and so, thinking that, I lend my VC pass to so and so, thinking that I'm helping that person, but see now the VC pass has gone to somebody else and this person is not returning the money also. Where is the judgment of the Supreme Court where it says that Lok Adalat can be interfered on the grounds of fraud and all that? There's a judgment. Since Lok Adalat awards are basically on the basis of a compromise, they are not supposed to be challenged. They cannot be challenged. Only grounds for which it can be challenged is that it was obtained by fraud or by misrepresentation or something like that. There's a Supreme Court judgment. The judgment which you have given is basically that Lok Adalat cannot adjudicate the case
Yes.
like a civil court.
Yes, sir.
And sum and substance is that if there's a compromise, okay, fine. This is a compromise, we sign. If there's no compromise, they cannot adjudicate. You will give, this person will give that, and he should give it under this law, that law. That will not happen. That is a admitted principle. Only thing is that if somebody had played fraud or something was done which you could not understand, it was not with your knowledge, in such circumstance, the Lok Adalat award can be questioned and perhaps interfered with. So you get hold of the judgment, let's see. Ms. Linda, anything you want to submit at this stage?
Yes, that is the judgment that I want to submit.
Oh, you're relying upon that?
Yes.
Let us see. Which paragraph?
Page 23, paragraph 35 and 36, my lord. Shall I proceed, my lord?
Yes.
It is a settled position of law that
Page, paragraph?
paragraph 35,
35.
page 23.
35.
35, paragraph 35, page number 23.
Yes.
Yes. It is a settled position of law that where an allegation of fraud is made against a party to an agreement, the said allegation would have to be proved strictly in order to avoid the agreement on the ground that fraud was practiced on a party in order to induce such party to enter into the agreement. Similarly, the terms of a compromise decree cannot be avoided unless the allegation of fraud has been proved. In absence of any conclusive proof as to fraud on the part of the objectors, the High Court could not have set aside the compromise decree in the instant case. Next para, my lord. Having considered the aforesaid fact of the present case, we are of the view that no ground was made out warranting the decision of the High Court to set aside the order of Lok Adalat dated 7 July 2012, wherein compromise was recorded between parties. The High Court's decision to set aside the order of Lok Adalat without entering into a discussion as to the findings in such order cannot be sustained. Such decision of the High Court runs contrary to established principles of law which seek to protect the sanctity and finality of orders based on the compromise or consent between parties. My lord, it is very clear from the judgment itself. And with regarding to the facts of the case as well as the award, it is really apparent that she has relinquished her rights, the petitioner. And there is no fraud or coercion or anything else when it comes to the award. She herself signed it, as you are well aware, my lord.
See, apart from the award,
Yes,
was there any such kind of compromise settlement between the parties?
Yes, it was there.
Where is that?
I mean, the award itself was the
No, award is one thing. Before
Okay.
award was passed, was there any compromise agreement
No.
between the parties?
No.
You see, what happens here, especially in this court also,
Yes.
there's a case. Then both parties, they say that we are attempting an out-of-court settlement. Then they want some time. Court gives time, okay, take 2, 3 weeks, 4 weeks time. And ultimately they, in some cases, they agree. Then they make some agreement.
Yes.
Then they produce that before the court.
Yes.
That on the basis of that agreement, the court says that the matter is decided or the matter is disposed of in terms of the agreement reached between the parties. Whereas in the Lok Adalat, what we are seeing here is just the award. Was there any sort of any agreement between the parties that we are ready to sign or we will go ahead with this?
As far as I'm concerned, my lord, it was not
Okay.
there. But
Straight away it was recorded in the order, that's all.
yes, but I think ample time was given to her also at the same time, because in the VC sitting, it was actually also like very clear. Because even ample time was given to them, not only to her. And then she also said she doesn't even contest against it. At the same time, again, after approaching Lok Adalat, she was summoned. She didn't say anything. No objection was filed. And if that is the case, my lord, the very same day she actually took the money also, 50,000. Today, if she made up her mind, today I want to do this, and then award has been passed tomorrow, then she changed her mind, my lord, then what's the point of going to Lok Adalat? What's the point of the award, my lord?
What about the remaining amount?
The
How-
remaining amount has to be given by respondent number 5. So if she wants remedy against the respondent number 5, then she has to approach appropriate court for execution, my lord.
My lord, if I may intervene in that, my lord, even this 10,000 which is to be given by Silal Tanpuya and Lelrolua, I don't receive it, my lord.
Even
Not received yet.
Even if that is the
Though
case,
it's written in the Lok Adalat
he
in
can-
the last 3 lines. Page
the,
number-
the petitioner can approach civil court, my lord, for execution under order 21.
Where is that 10,000?
Point,
In the
last
award.
3 lines in awards, my lord. May I read out, my lord? Page number 1, my lord. Last 4 lines, my lord. Hem mitchin fel nan hian pulal ro hlua lawa kanan le silal tan puya te ten pilal sang zoli tan pui nan cheng sing khat ve an pianga oga somni pani chungin an piang. Not received yet, my lord. Though I received that 50,000, as I said, because at the date of Lok Adalat award, actually my house, my VC pass, though my daughter is still there in possession, it's already mutated in the name of respondent number 1. As I am informed by the conciliators that I don't have any other option remedy, so I don't have any other option.
My lord, adult.
It's in fact, my lord,
You're adult.
my
You
daughter,
cannot
who is
force people. You just
daughter
can't
of
go
the
keep
petitioner
someone-
is still in possession of the one building, my lord. As I submitted, 2 Assam type building are there.
My
One is
lord,
rented out and one
even-
is in possession of the daughter of the petitioner, my lord.
The order sheet itself was really clear about the.
If it's a
award.
compromise, Lok Adalat, actually
It
they
says
must.
deliberately, like the
Okay.
time frame was.
Okay, I think we'll do one thing. You save the arguments for another day. You are for which respondent?
Very relevant, my lord. He is for respondent number 5, my lord. Respondent
now-
number 5, who is the person who borrowed
See,
money from. number
although
one.
we have got some background knowledge about what has happened and all that, but it's better this matter to be taken up by some other bench.
My lord,
have been-
you being the person, the judge who first, I think, listened the matter initially also.
The merits.
Because suppose if the Lok Adalat award is set aside, we need to file a civil suit in
I
before
know,
district court.
whatever it may be. But
it
there are
can
some
be-
difficulties. I have to recuse myself
Oh,
that way.
all right.
I wanted to know what the story was. You had explained to me elaborately, no doubt, but it's better. If there's urgency, we'll fix it up next week.
My lord, as soon as possible, because
soon as possible.
it has been dragging for a very long
Since
time.
2023, my lord.
Since 2023, my lord.
Today's 24th, isn't it? All right. This is for hearing otherwise, isn't it?
Yes.
Yes.
So you'll come up in the hearing list, or you want a particular date?
If specific date can be given, my lord,
Ah.
because we are not regularly coming before this honorable House.
Tuesday. Monday is a holiday, I think, next Monday.
Yes.
31st is a holiday. First is
Any date, my lord.
list this matter before any other bench and not before me. No, you cancel the order. List this matter, as prayed for by the parties, list this matter for hearing on 1st of April, 2025. What about the other case? It's still pending.
MACT appeal, my lord.
That's MACT appeal?
Yes, it's,
Not related to this?
yes. I'm quoting that case only because
The council is there?
Yes, yes, yes,
Council
exactly.
had given some advice.
Yes, madam.